Thank you, donors. With the consent of the respondent, I take to mention item number 55. This matter is taken by senior secretarial group. This is a professional problem is not able to come home to the nurse. So kindly accommodate only for the.
55 of the supply list.
Lordship?
55 of the supply list.
Yes, Lordship.
When do you want?
21.
When do you want?
Next week.
Okay. On a request made on behalf of Sri K. N. Chaudhary and Senior Counsel for the petitioner, matter is adjourned to be listed on 16th of March. 55, huh? 16 March, interim order passed earlier, huh? Okay.
May I please? I am paying for listing this matter for motion on ordinance.
Yes.
I am not well.
Okay. Okay. On a request, on a request made by Sri K. M. Haloi Learned Counsel for the petitioner, matter is adjourned to be listed on Wednesday. Day after tomorrow is okay, or Friday also we can have, no problem.
This case, Lordship, remission, Lordship, the review medical board will review.
No, he's not feeling well. Will consider day after tomorrow?
Sitting in the month of July 26th, in the order it is reflected. How it is coming, that's why.
No, you are supposed to get instruction
Because the
takes on.
review-
Okay, day after tomorrow we'll pass Wednesday, huh?
My lords, in item number 40, the petitioner does not
40.
40. The petitioner does not wish to press the petition.
Sri A.P. Pathak, Learned Counsel for the petitioner submits that there are instructions not to press this petition. Also heard Sri S.S. Roy, Learned State Counsel, Sri A.I. Ali, Learned Standing Counsel, Election Commission of India. Who is S.P. Chaudhary for whom? And any CGC here? It is SP Chaudhary, SP Chaudhary, London CGC para. Dismissed on withdrawal.
May I please your lordship?
Yes.
I beg to one read petition for listing in this month, last week of this month,
For motion or what?
for admission. The matter
Matter of which year? Matter of which year?
2024.
24, what is the urgency?
Urgency for allotment of the land
Sorry.
in the petition.
Not by mention, not by mention memo.
The matter was lasted in the month of May.
Not by mention memo, you apply before the
I have already applied my lord twice.
Doesn't matter. Doesn't matter. Not by mention. Mention memos are not for that. Yes, madam.
Item number 45, we filed an application on behalf of respondent number 6, 7, and 8. But may allow to kindly bring that.
Yes, bring it.
If I may, my lord, I beg to mention a writ petition, my lord, for orders, my lord.
Orders which year?
My lord, 25, my lord.
25, what is the urgency?
My lord, there is an application pending, my lord, before the
You
circle.
you have to show an urgency for out of turn listing by a mention memo. Mention memos are only meant for urgent matters and motions.
Yes, my lord.
Not
My
for
lord,
others.
there is some urgency, my lord.
What is the urgency? Tell us.
My lord, the respondent number 15, he filed an application before the circle officer.
Those are not urgent matters. The urgent matters means tomorrow something is going to happen. Sorry, next. Motion is, yes.
Please, your lordship. Lordship, I back to list, back for a listing, your lordship. For fresh matter, your lordship. Can it be tomorrow,
Okay.
your lordship?
Tomorrow, why
This is the
tomorrow?
Eviction matter, your lordship.
Okay, we'll try tomorrow.
Obliged, lordship. May I please?
Yes,
I beg to mention item number 14, my lord.
1-4.
One for my lord.
Yes,
My lord, on behalf of Mr. Sportive Day, my lord, he's today not available. On Wednesday, lordship, I've taken something from the other side. 14.
14.
Yes.
Okay. On a request made on behalf of Sri S.D. Learned Counsel for the petitioners, matter is adjourned to be listed on Friday? On Friday.
Deeply obliged.
Date. 38 and? Yes. Yes. Okay. Our request for adjournment has been made on behalf of Dr. E. Saraf, Learned Senior Counsel for the petitioner. Para, considering the above, matter is adjourned, is adjourned to be listed on, today is 9th, on 23rd of March. 23rd March, interim order, if any, stands extended till the next date of listed. 38 and 53 of the supply list.
Yes, sir. No, daily leave.
Daily last matter. 53 is so hearing, it ever 23rd, no? Okay.
May I please, your lordship? Lordship, I beg to mention for an adjournment, your lordship, item number 49, your lordship.
49,
49, your
yes,
lordship, there is some personal difficulty of my senior.
okay,
He begs for an adjournment, your lordship.
okay.
Okay, very-
Revenue Department? Yes. Item number 49, okay. On a request made on behalf of the petitioner, matter is adjourned to be listed when? Next Wednesday?
Lordship, can it be on first week of April, your lordship?
Matter is adjourned to be listed on on 1st of April. One,
Lordship, interim is there.
1/4.
Interim. is
Interim
there.
order passed earlier to continue till the next date of listing.
Obliged, your lordship.
May I please, Lordship, I beg to mention item number 25, motion matter matter.
25, yes,
I have some personal difficulty, I mean, for the petitioner matter.
okay.
Can it be taken up on Wednesday matter?
Okay. On a request made on behalf of the petitioner, matter is adjourned to be listed on Wednesday. Wednesday means 11th,
Yes,
11.
I leave it.
May it please, your lordship. Lordship, I beg to mention for listing a matter for motion for Wednesday, lordship. Oblige, your lordship.
Similar prayer.
Yes,
Similar prayer, my lord.
motion or what? Okay, okay. Yes,
May it
madam.
please, your lordship. Lordship, I beg to mention for listing of a writ petition, lordship, for motion. Lordship.
When? Wednesday.
Wednesday, lordship, obliged.
Have you filed or not?
Yes, lordship, we have filed.
Yes, madam.
May it please, your lordship. Lordship, I beg to mention for listing of two writ petitions for motion.
Wednesday.
Yes, obliged.
Okay. Under 9 again. Yes, 1 to 4 are for revenue. Yes, what is
My
it?
My lord, this is a matter, my lord, wherein we have, my lord, prayed before my lordships, my lord, to file the rejoinders, my lord, and we have prepared it, and today it is being filed, my lord. Certain documents, my lord, we got, my lord, admittedly, they claim.
Then let the rejoinder be filed. We'll have it on Wednesday next
Yes, my lord.
or Friday next, whenever you say.
Friday.
Friday,
Like-
okay. Sri A.R. Bhuya, learned counsel for the petitioners in these cases submits that the rejoinder affidavit would be filed during the course of
My
the
lord.
day. Full stop. Let such rejoinder affidavit be connected with the records and the matters be listed on Wednesday.
Mal. My lord,
Huh? Day after tomorrow. Okay? Or you need some time to have it, then Friday.
My lord, interim orders are there, my lord.
What kind of interim order?
My lord,
Interim order, if any, stands extended till the next date of
Mal.
listing.
obliged.
Common order, did you? Friday, hello? Item 5. Mr. Chaudhary, what is this matter?
My lord, non-issuance of PRC. No, my lord, because he doesn't possess 50 years of any documents, lordship. We have asked him to produce that.
My lord. Petitioner's great grandfather were.
Then in that case, we'll issue notice. Let him also get a chance. And you have to file an affidavit. Okay? Third. 3 AHMR Chaudhary Learned Counsel for the petitioner who is aggrieved by non-issuance of PRC, which is required for her for pursuing her educational journey. Full stop. Para. On an earlier occasion, this court had directed the Learned State Council to obtain instructions. Full stop. Sri Roy, the Learned State Council has submitted that written instructions have been received whereby certain reasons have been cited. Full stop para. In that view of the matter, let notice be issued returnable on. Are there any private respondents, Mr. Chaudhary? No. Returnable on. We'll have a short date. Can we have it on 30th? 30. But you have to file your affidavit before that. On 30th of March 2026. Miss P.R. Mohanto, Learned Standing Council Revenue 1 and SS Roy 2, extra copies. By the next date, 3 Roy, the Learned State Council is directed to file the affidavit in opposition. Item number 6.
Your
Yes.
Lordship, in the light of the observations made by this honorable court in the previous hearing, certain concerned police officials were to be impleaded and proper framing of prayers were to be done. So it appears that, Your Lordship, substantive changes would be required to the writ petition. And also for the allegations of mala fide as well, certain
What was the issue? We had considered that one occasion. What was it?
Your Lordship, it was about harassment by the police and unlawful detention of the petitioner.
Okay, yes.
Yes,
We'd like to amend this or file afresh.
fresh, Your Lordship.
Yes, Mr. Singh.
Yes, sir. I have a discussion with amicus, so he told me better to file a new writ
Then
petition.
we'll grant you liberty. Okay.
Not obliged, Your Lordship.
Heard. You are A. Chakraborty.
Yes, Your Lord.
Heard 3 A. Chakraborty, learned amicus curiae for the petitioner who is also present in person. Full stop. Also heard 3 SS Roy, Learned State Council. Para. This matter was considered on 2 earlier occasions. Full stop. Occasions and instruction and the matter was deferred to enable the petitioner to reconsider. Full stop para. Both the learned amicus and the petitioner in person has submitted that the writ petition be allowed to be withdrawn with liberty to file afresh. Full stop para. In view of the above, writ petition is dismissed on being withdrawn with liberty as prayed for.
Not obliged, Your Lord.
This is the matter relating to development schemes of
Yes.
Algapur.
Yes.
May I, before,
Instructions?
may I,
Receive the instruction. I want to file affidavit.
Lordship, there is a bit of inaccurate instructions that we received. We have averred that we have not received notice. Notice has not been served on us, but we now discover that a WhatsApp was sent. May I file an affidavit explaining that
You also
paragraph?
file an affidavit, but because this will be relevant in the adjudication
Yes, but
process.
7 days notice has been not followed. It's just,
You can explain it in your affidavit.
yes, yes, Your Lordship.
Oh, okay. Heard.
No, notice
Miss-
will be issued, my lord.
No, we're issuing notice.
Yes.
In the meantime, she'll also file additional affidavit.
Yes.
Heard Miss G. Goswami, Learned Counsel for the petitioners. Full stop. The subject matter involved pertains to an allegation of discrimination in allotment and distribution of funds pertaining to the Algapur Anchalik Panchayat. Full stop. On the earlier occasion, when this matter was considered, instructions were directed to be obtained. Full stop. 3. Dr. S. Dr. The Learned Standing Council PNRD has submitted that written instructions have been received. Full stop. Para. Ms. Goswami, the Learned Counsel for the petitioners, has also sought. No, it is applicable. Received. Let notice be issued. Returnable or returnable. We give a date, madam. Today is 9th. We'll have it on 1st of April. Is it okay for you? 1st of April. Sri S. Dr. Learned Standing Council for 1, 2,
1, 2, 4, and 6.
1, 2, 4, and 6. 3, then 5. Who's 5? 5 will go by speed post.
Yes, ma'am.
5, 7 and 8. 7 and 8 you are repairing already. Okay. You are Borbia. 3 MH Borbia has entered appearance for respondent numbers 7 and 8. Only 6 who remains then? 5. Extra copies. 5 speed post to TD, huh? Ms. Goswami, the learned counsel prays for a liberty to file additional affidavit to explain the aspect of issuance of notice. What's the additional affidavit may be filed before the returnable date.
Obliged, Your Lordship.
Yes, madam.
Lordship, this is relating to, Lordship, the passing of the impugned order without issuing any so-cause notice. Lordship, in fact, this honorable court has passed many order. Lordship has also passed the judgments in which it has been interpreted and it is demanded back to the, so Lordship, they were about to take instruction.
Are you agreeing with this proposition?
Just now, extra copies, madam. We'll have our instructions.
Okay, we can have it on Friday then, madam.
Lordship.
If those are covered, we'll dispose on Friday.
Yes, sir.
If those are not covered, we'll see.
Yes, Your
Okay.
Lordship.
Perhaps these are covered. Okay, giving another chance.
Yes, Your Lordship.
In 1 or 2 cases, Mr. Mishra, we had passed some
Yes,
orders.
it's in the judgment as
Uh,
well. Passed.
You are in both the matters, madam?
Lordship, I'm in item number 8. Mr. Mishra is appearing for the item.
Heard Miss Anne Havelia for the petition for land council petitioners, petitioner in so and Sri R.S. Mr. So. Well, while both the learned counsel for the petitioners have submitted that the issue would be covered by earlier judgments and orders, comma, Sri H. Barua, learned counsel, standing counsel, learned counsel for the learned counsel representing the finance department has prayed for some time to obtain necessary instructions. Para? List for motion on Friday.
Item number 9 is an interim order.
Lordship, even,
Financial taxation.
Finance and taxation.
Lordship,
Interim order, if any, stands extended till the next date of listing.
in item number 8, there is no interim, Lordship, no coercive measure, Lordship.
Okay. Last one, it is provided that till the next date fixed, no coercive action be taken against the petitioners.
May it please your Lordship.
Yes, madam.
This is regarding payment of compensation amount. The compensation they have already received under the Zamindari Act, but my lord, that interest part is still to be paid. That's why they are requesting this court under the act provided in section 21. That
21 of
21 of the Assam State Acquisition of Zamindari Act 1911.
The word was passed in the year 2011.
12, they have sanctioned the amount for compensation. But compensation amount they have.
when did you
received
receive?
12.
Now, why have you come to the court after 14 years?
They tried, my lord, they applied there, but my lord, no reply was given. Only verbal assurance was given. As provided under the act, they should be given. So, my lord, they are approaching this court now.
But coming to the court after 14 years.
Not
14 years.
the similar order is, I have annexed, my lord, and close here, page 30. There, my lord, only interest part was, my lord.
In
Because
that case, when was the award dated? What was the date of the award?
Yes, my lord. We are also delayed, my lord, then 8-10 years delayed.
Heard Miss Anne Sekia, learned counsel for the petitioner, who by this petition has made a claim of interest upon the compensation amount paid for acquisition of land. Full stop. Such claim has been made under section 21 within bracket 3 of the Assam State Acquisition of Jamindaris Act 1951. Full stop. Sri S.S. Roy, learned State Council has, however, raised an objection of delay and laches inasmuch as the award is of the year 2012 and this petition has been filed after about 14 years. Full stop. Para. Be that as it may, let notice be issued returnable on 6th of April 2026.
They are also, my lord, that 10-11 they have paid. but
Madam, 1 and 3, finance. H. Barua for 2
4 and 5.
and SS Roy 4 and 5. Is there a compensation officer, Mr. Roy?
Yes, my lord.
Huh?
Compensation officer, but my lord from the Department of Revenue and Disaster Management, they may not.
No, is there a designation of a compensation officer?
No, sir.
Hmm? From where do you get compensation officer, madam? We have not come across. Is there any communication by the compensation officer? From where do you get this nomenclature? There is one,
Compensation officer, my lord, because my lord, some of the ADCs are assigned mostly.
Okay, there is one communication at page 28.
Time to time, some.
Madam, at page 28.
Page 28.
28.
Now it will be.
Maybe the designation has changed. This is by, have you come to page 28 to 8? It is signed by one compensation officer.
Compensation officer.
Okay.
Seven Barua.
This is
ADC,
okay.
he was working there as ADC, he was assigned as compensation
Okay,
officer.
5-0.
So time to time, some different compensation officers are appointed.
The aspect of maintainability of this writ petition
One can
on the ground of laches, however, is kept open. Okay.
Government will accept notice on behalf of him also,
Yes, we have told.
obligement.
Yes, Mr. Decker.
The matter pertains to illegal occupation of the Patalata petitioner by the respondent PWD authority lordship.
Yes, madam, where are you occupying his land? You are the Public Works Department. Which place? Where?
Rehabari lordship.
Rehabari?
Yes, Lord. Land
Good.
belongs to the father of the petitioner, who is Surendra Mohan Deka. He was a judicial officer lordship.
PW is occupying.
Occupying Lord.
Oh.
In the nearby land belongs to Fakhruddin Ali Ahmed president. That land was first occupied, thereafter encroached upon this land.
Yes, madam.
And interestingly, same PWD department has acquired a portion of that land and acquisition compensation has been paid to us.
Okay. Heard 3S Deca, learned counsel for the petitioners who are aggrieved by illegal occupation of their Miadipata land by the Public Works Department. It is submitted that in spite of repeated requests, the land has not been vacated and therefore the instant application has been filed. Para, that notice be issued returnable on 1st of April 2026. Revenue, yes, madam, PR Mahanta 1. Public Works Department 2, madam Sarma for 2, 3, 2 and 3. And 4 and 5 is SS Roy. Extra copies. Public. Madam, you take instruction.
Yeah.
May I please, Your Lordship?
Mr. Bora.
Petitioner has paid for releasing compensation for acquiring 2 plots of his land, Lordship.
For acquiring
For acquiring 2 plots of
land.
Miadipata land, Lordship.
When was it acquired?
Lordship, that Your Lordship will find the notice at page 30 on 28/3/2022. It is for construction of embankment in the district of Morigaon.
What is this, madam, here for whom?
For water resource.
Water resource. Yes, Mr. Roy, compensation not paid. How is it possible? Okay. heard Sri R. Bora, learned counsel for the petitioner, who is aggrieved by non-payment of compensation for acquisition of land. Full stop. It is contended that land measuring 1 bigha 3 katha was acquired under the provisions of the Assam Land within bracket Requisition and Acquisition bracket close Act 1964, whereafter no compensation has been paid. Correct? That notice be issued returnable on 6th of April 2026. Madam, what is your name? On behalf of Anam Das. You are on behalf of 1, 2, 3, 4 and 5. SS Roy, extra copy.
Roughly 2 plots of land are there. For 1 bigha 3 kotha, they have issued a notice under section 9(1) of the land acquisition.
Oh, not only that, there is another plot.
Yes.
Okay.
Another plot is
Well,
1 kotha 10 less. For 1
There is a
kotha
plot
10
to
less, they
Nelly.
did not issue any notice.
Okay. It is contended it is contended that 2 plots of land have been acquired, and for 1 plot even notice was not issued.
No, yes. May I pray for a date, Lordship?
We have given 6th,
Lordship. Authorized.
6th April. 13, yes.
My lord, in this case, my lord, I paid for my lord cancellation of my marriage, my lord, because my lord, the marriage registered, my lord, shown to be executed my marriage, my lord, in absence of me and as well as my lord, the respondent number 6, my lord. Therefore, my lord, I applied before the concerned Kazi, my lord, to cancel the marriage, my lord, but he did not do so, anything, my lord. Thereafter, I again, my lord, submitted appeal before the respondent number 2, my lord. But the respondent 2, my lord, issued an impugn letter, my lord, that is page 12, my lord. Sorry, my lord, 46, and except 12.
Yes. Mr. Roy? Who? Revenue, I think you take. Yes, what do you have got to say, madam? Heard 3A Hussain, learned counsel for the petitioner who is aggrieved by the inaction of the respondent authorities to cancel his marriage under the provisions of the Assam Compulsory Registration of Muslim Marriages and Divorce Act 2024.
No, my lord, 1935, my lord.
1935.
Yes, my lord.
Under the provisions of Assam Muslim Marriage and Divorce Registration Act 1935.
Yes, my lord.
Full stop. It is contended that the respondent number 4 had executed a false
My lord.
Kabinnama against which the petitioner had made a complaint, but no action has been taken.
Yes.
That notice be issued returnable on. There is a private respondent.
Yes, my lord.
Returnable on 10th of on 8th of April 2026. Madam, for 1 and 2 also. Inspector General registration will be taking, madam?
Yes.
1 and 2. Then 3 and 4. What about Muslim marriage registrar? I think you can take. 3 and 4, SS Roy, extra copies. 5 and 6, fit for security, stepped within 2 working days. 2 days will be corporate. Monday, Saturday night to Friday ordered 2 working days.
May please, your lordship. My lord, by way of the petition, my lord, I am.
Yes, Mr. Chakraborty.
My lord, I am assailing the order passed by the learned Board of Revenue Assam, starting from page number 134, my lord.
The relevant part is at page 137.
Yes, what is your?
Paragraph 6, my lord, will kindly see.
Hmm.
The appeal has been taken up and disposed of at the admission stage without issuing notice to the petitioner hearing, who was the sole respondent in the appeal. Now, your lordship kindly allows me to read the two paragraphs. In view of the above, and considering that the defect in the implain order is essentially one of non-consideration of relevant material, this appeal is taken up for final disposal at the admission stage itself without entering into the merits of the rival contentions on fact. The appeal is allowed to the limited extent indicated herein, and thereafter, my lord, the indications which were provided. Now, here, my lord, the crux of the background of the matter is the petitioner is the proprietor cum secretary of a private school of a concerned locality. Now, there
If
has
it has
been
been disposed of without notice, we'll definitely examine this.
My lord, that has to be.
At this stage, let us issue. Yes, here for whom?
For the respondent numbers 5 and 6, your lordship will kindly see paragraph 12 of the order. The matter was
No,
remanded back
but-
to the settlement officer
Yes.
to take a fresh consideration, hearing all the parties, urging all the contention on law and fact.
No,
Therefore, lordship,
I
that
have.
is pending
No,
for settlement.
He is a party in the proceeding.
Lordship, I am told that.
Is it not required for to give a hearing?
No, lordship, that was only remanded back for.
Even for a remand, is he not entitled to have his view? Only for that matter, not on the merits. Maybe the same order would be followed.
Revenue board also, lordship, had likely not gone into merits because the other side was not there. It was only
Hmm.
remanded back. And I am told that the next date of hearing is on 16th of March. They have entered their appearance before the settlement of.
But that is a fact. It is on 16th of
Now,
March.
can you trash it out at the settlement officer's
My
level?
lord, the difficulty is there has been upteenth number of proceedings before the assistant settlement officer and the settlement officer.
But one thing, he may be correct in contending.
My lord,
Yes, you have not been heard, but what is the prejudice? The revenue board has not expressed any opinion on merits.
no. Here,
The
my
matter has been remanded by giving you an
My-
opportunity. You have already entered
lord,
appearance.
my prejudice,
Yes.
I'll explain, my lord. This is a school which is on the verge of getting prior
Recognition.
permission and registration from the Department of Education. Now, for that, possession of land is something that is required under section 12(1) of the Assam Non-Governmental Educational Institution Regulation and Management Act. Now, I am told, my lord, that this procedure is going to take place on the consideration of whether there is land occupation or land possession is to be taking place on 15th of March, which is a day prior to the hearing before the SO. Now, here, if this order is holding the field, then my registration for the school or obtaining of permission for the school, which has 350 students enrolled therein, the future of those 350
What was
students.
the matter which was the impugn order was before the revenue board? What was the order?
The order was, it was also an order by the settlement officer in an appeal, in the miss appeal, which was filed by me,
Yes.
against an order by which my mutation was cancelled.
Now that has been restored.
Now, that has been restored only
Okay.
for.
Some rights were.
Oh, my lord, your lordship kindly sees the restoration order. It is only for a limited purpose.
No, we are only asking you a very pertinent, specific query.
My lord,
The matter which was the subject matter of challenge
My lord.
before the revenue board,
My lord.
what did it confer? Did it confer you any right?
the revenue board,
No.
the one before the settlement officer.
No. The order which was impugned before the revenue board,
My lord,
by that order was any right conferred to you?
to the extent of restoring my mutation of the school, mutation of the name of the school. And
then probably we'll
to the yes.
issue notice.
My
Lordship, if I may just place
Now,
one.
if that is set aside,
Lordship, one fact, lordship. The issue before the revenue board was a letter in order dated 7/2/2024. Lordship, only for a moment, lordship. That was a provisional land mutation information. We came up before this honorable court stating that this is a mutation order.
no, if some right was, no, we'll issue
I
notice.
don't
We'll
know
issue notice.
why my learned friend is.
We'll issue,
arguing
we'll
to me.
issue, we'll
He is
issue.
not
notice.
even caveat. That is the unfortunate part of it. He is the one who has been making, and he is the mother of the petition.
Very well. Lordship,
You are not having a power to appear.
Lordship, only one aspect.
Do you have the power to appear?
Lordship, we learned from our seniors that the order which I am relying upon, in the same matter, my learned friend appeared without a caveat.
No, that way you should point it out
I
because one wrong has happened somewhere, so that wrong has to be sustained.
Please.
Sorry, we're not going to hear you like this.
Lordship,
We're not going to hear you.
I'm finding my vakalat number.
When?
today, Lordship.
You file it, then you come.
Only one aspect before Lordship, there is the
How
order.
can we hear you? You are not on caveat. You are making a submission as if we thought you were in caveat. Then also would have been, we are not that technical. You should at least file your power.
Because a wrong submission has been made, a mutation order was never issued. That was clarified by this honorable.
You do whatever you want after you have the authority to make the submission. You do not have the authority.
We are filing, but it came out on Friday. We are filing it today.
Well, why haven't you filed till now? It's now 11 o'clock. You need time to file a wakalat number half an hour, more than half an hour.
The order assailed is of 13 November, my lord. The order assailed before this honorable court is of 13 November.
That was clarified by the
Heard.
honorable court.
Sri D. Chakraborty Learned Counsel for the petitioner who is aggrieved by an order dated 13/11/2025 passed by the learned Assam Board of Revenue in case number 76 RA within bracket C/2025, whereby the appeal has been allowed allowed at the admission stage without even issuing notice. Full stop. Para. That notice be issued, returnable on 6th of April 2026. Revenue Department is Ms. P.R. Mohanta for 1 settlement officer.
1, 2, 3, and 4.
No. Assam Board of Revenue they will not take perhaps. Do you take for Assam Board of Revenue? Mohanta for 1, I think, and Roy for 3 and 4. Extra copies 2, 5, and 6 by speed post with AD. Steps within 2 working days. Full stop. Para. 3. Chakraborty to Learned Counsel prays for an interim order. Full stop. Considering the facts and circumstances, and also the fact that the impugned order has been passed without issuing notice, comma, the same shall stand suspended till the next returnable date.
Deeply applied.
G Assam be reflected in the call list.
Deeply applied.
Since this, we'll make an observation, Mr. Since this order has been passed ex parte, who are the private respondent, they would be at liberty to come up for alteration, modification, if so advised.
Deeply.
Yes, Mr. Das?
Lordship, in this case, the petitioner's mother was the owner of a plot of land which was subsequently acquired by the government for the purpose of widening of the 4-lane. Now, Lordship will see the petitioners have already received the compensation in respect of the land. It is only the zirat which is pending. Lordship will find the notice at page 24. The notice was issued under 3E. Lordship, may I just point out, Lordship, the amount of the zirat was fixed at 13,34,800.
So your present claim is with regard to the zirat?
Only the zirat, Lordship.
Will issue notice, madam. Zirat he has not received. Will issue notice at this stage. Has any assessment been made?
Assessment has been made, Lordship. In fact, the assessment was re-verified. That your Lordship will find at page 29.
Heard. We am thus Learned Counsel for the petitioners. Full stop. The grievance of the petitioners is with regard to non-payment of the zirat amount for land which has been acquired. Full stop. It is contended that while the compensation amount has been received, comma, the zirat amount, comma, though assessed, has not been paid. Para. Let notice be issued, returnable on all official respondents or are there on 6th of April. Union of India, who's accepting notice? 1 Union of India Transport Department. Highways Transport 1. Madam Bora for 1.
4 and 5.
1, 4, and 5. Then Revenue Department, PR Mohantaka for 2, 2. 3 is National Highway Authority of India, 3 C Borwa Steering Council. 6 and 7, who's there? 6 and 7. Okay. 6 and 7. What about 8? 8 and 9 as Sharma, huh? Extra copies. Okay.
Lordship, I have a small prayer for interim Lordship. Lordship, what has happened was, Lordship, initially the amount which was fixed, Lordship, even that amount has not been released. That is an admitted amount, Lordship. At least to that extent, minus the enhanced amount, can it be released, Lordship, at this time?
3, thus the Learned Council prays for an interim order, sir. After considering it is provided that there will be no bar for releasing the payment which payment of the assessed amount.
Lordship, all right. Well, side 17 also is a prayer for Zirat, Lordship.
Same.
Same.
And the respondents are the same.
Respondents are also same.
Okay, same order. Huh?
All right.
Here also some interim was
No, Lordship, because this is only in respect of the house which was over a government patta land.
Okay, blast out on interim.
All right, Lord.
Item 18. Yes, Mr. Sahu.
Yes, my lord. My lord, this is the petition is filed challenging the impugned order in original passed by the respondent number 3, which is without jurisdiction, and confirmation of text is also without authority of law. And this matter has also been settled by the Honorable Delhi High Court, and the matter has been accepted by the department. Subsequently, before the Supreme Court also, the department withdrew that petition also, and the matter is on that is settled.
Yes, what do you say?
This lead petition is not maintainable because they have challenged the impugned order in original as well as recovery notice.
Yes.
But against the order in appeal, they have approached the sestate. Your lordship will find the order at page 192.
The appeal is pending.
No.
Has been
They-
dismissed, lordship.
That is on ground of limitation. They are not going to the merit of the case. On the ground of limitation.
But how do you reopen unless you or challenge that order of sestate?
My lord, I am not challenging the order because that's on limitation.
No, whatever
Not
is
merit.
it, if it is dismissed on the grounds of limitation,
Yes, my lord.
the dismissal is on law also on the merits.
Merits, lordship.
That is the law.
Actually, this is from the very beginning.
It's not a
how the-
technical kind of a dismissal. Once
My
it
lord.
goes, it goes. You have to put that
once-
on also on the challenge if that is
My lord,
existing.
here, actually, initially, I before this honorable court. in
Mr.
2013
Sahu, you may have a case for consideration, but unless this estate order is put to challenge, in the meantime, you have said the matter has been settled by the Honorable Delhi High Court and upheld by the Supreme Court. We can apply that, but here on the face of it, there is a estate order which has to be interfered with.
No, that has been dismissed on the ground of limitation. He sustained the order of the commissioner appeal.
Now that has attained finality unless that is put to
Then-
challenge.
Yes, that is there.
You have
but-
you have to challenge it. Put a challenge, amend this petition.
Appeal before the Honorable High Court, lordship, and that's section 35G of the Central Exercise.
No,
There
that
is a
is-
provision, lordship.
My lord, that is an appealable ground.
That is.
That is on the appealable ground. On
There will be
substantial
difficulty.
question of law, but here I am challenging the legality of the impugned order in original recovery.
Because the
See that
Because this
that the subject matter which is impugned in this proceeding was already subject matter in this estate appeal.
appeal
Now estate appeal has been
Dismissed.
dismissed on the grounds of limitation.
limited without.
No further appeal has been filed under 35G. No further
That
appeal.
is, that is a separate way of filing appeal before.
How do you have some parallel proceeding?
Because the order in origin is arising out of the same appeal.
You cannot have a parallel proceeding. If your estate appeal was not there, you come before the writ court, we would have found out a way.
Actually, initially from the very beginning, this order is a defective without jurisdiction. But this matter has not been decided by this honorable court, nor by the tribunal, nor the commission appeal, my lord. So this is the upper in all over India.
And what is your difficulty in preferring a 35G appeal?
My lord, it's only limitation, but because there is a.
No, what is the difficulty in 35G appeal?
Limitation actually.
If it is a decided case,
Substantial question of law, when
the substantial question will come. When substantial question is there, when it is without jurisdiction, that will be a substantial question.
so that can also done. So
I
but
think
here
that will be a procedure. You have already taken a recourse You have taken away. Now you cannot alter, you cannot come into another way. That way has ended up in a finality by the dismissal of the appeal by the estate. So
My
you
lord,
think over, we'll have it on
my
Wednesday.
lord,
Wednesday we'll
my
have
lord,
it. We'll have it on Wednesday. You can have the instructions. If you want to withdraw, we will allow you to withdraw and file.
yes, yes, my lord.
I think. Are you there till Wednesday?
Yes, I am being witness. My
Okay.
lord, actually, in annexure K 192 page number can be seen the state order. They have not gone the merit.
No, we have, Mr. Sahu,
Yes.
we have understood your
Yes.
case. Sestate has not gone into the marriage, but Sestate has dismissed the appeal on the grounds of limitation.
Yes.
But once it is dismissed, it amounts to a dismissal on the merits of the case also. It is not necessary. That is the settled position of law.
None appear for the petitioner also.
Day after tomorrow.
Yes, my lord.
Okay. You take instructions.
Yes,
Okay.
my lord.
Heard Sri D. Sahu, learned counsel for the petitioner, full stop. While it is contended that the issue is settled by the Honorable Delhi High Court,
Delhi High Court.
which has also been upheld by the
Not
Honorable.
upheld. On SLP, department itself withdraw the case.
Okay. Delhi High Court, and the appeal referred by the department before the Honorable Supreme Court has been withdrawn, Sri K. Jain, learned counsel, appearing on instruction of Sri S.C. Kyle, learned senior standing counsel for CGST, has submitted that against the order in original,
Order in appeal.
the Sestate was approached, which however has dismissed the appeal on the ground of limitation. He has submitted that no further appeal under section 35G of the Central Excise Act 1944 has been preferred. At this stage, Sri Sahu, learned counsel, prays for some time to obtain instructions. List on Wednesday. Give the date. Mr. Jain, you also think over if the issue has been settled, whether a writ court can, in an extraordinary jurisdiction, can do something.
This appellate provision, they can raise this issue before the.
We are just thinking whether it will be an effective remedy. We are just thinking over. Okay.
May I please, your lordship? Lordship, another similar matter is being fixed on 23rd.
Item number, madam? 19.
Yes, lordship.
Yes.
So this instant matter may be tagged with that matter.
What is the subject?
It is regarding the non-payment of solution amount by the National Highway Authority.
Land has been acquired.
Yes, lordship.
What is the other matter?
Similar matter.
Number?
3496/25.
When is it fixed?
23rd 3/26. 23rd of this month.
23.
Yes.
Okay, what is your name, madam?
Dear Bangshari.
Ms. D.R. Bongsheri, learned counsel, has submitted that an identical matter has been fixed on 23/3/2026. Full stop. Also heard Ms. Egan, CGC, SS Roy State Council. Madam, you are also there? 4? No, 4 and 5. Who are 4 and 5? NHIDCL. NHAI. PR Mohanta, Revenue, accordingly, list on 23/3/2026 along with WPC
3496.
3496 of 2025. 5.
Yes, lordship. Highly obliged, lordship.
May please, your lordship.
Yes.
Lordship, I had a cash credit account, loan accounts. And lordship, I had a sanctioned loan amount of rupees 3 lakh rupees, which is further enhanced to rupees 5 lakh rupees, lordship. And I have totally repaid the loan amount, lordship, in December 2025, lordship. Lordship, after, however, there was a transaction, alleged transaction of rupees 20 rupees, which is some subject matter of a cyber complaint. So
This was that matter where you have given liberty to
no,
verify.
that is not
Different. What is it here? You had a cash credit account.
Yes, yes. Yeah. Cash
Who are
credit-
you? You are an individual.
Yes, lordship, I am a sole proprietor.
CC account. Where? Which bank?
It's a Bandhan Bank, Lordship.
Bandhan. Then what happened?
Lordship, I had, the amount was 5 lakhs rupees. It was initially 3 lakhs, which was enhanced to 5 lakhs rupees. I had totally repaid the loan amount, Lordship, in December 2025.
Repaid.
Yes, Lordship. Loan has been repaid. However, there has been a transaction of rupees 20 because it's a cash credit, it's a flowing account.
Oh, yes.
So 20 rupees transaction, which is subject matter of some cyber complaint. Now, when I go for a no due certificate or a no objection certificate, the bank is refusing because of that particular 20 rupees. So, Lordship, because of that, I'm not able to avail further credit. And
Yes, so Bandhan, there is no, we have to issue notice. We have to issue notice. Is there any concept for Bandhan Bank? I don't think so. We have not- You're Mr. Deka?
yes, Lordship.
Which branch? Which
It's
branch?
Patikia in
Murigaon.
Murigaon.
How do you serve them? Can you serve them dusty? We could have expedited your matter. Okay, well, heard. What Deka do you write? What is your name? You're not on record.
No, I'm on record, Lordship. In the CIS, I think.
I heard Sri K. Deka Learned Counsel for the petitioner. Full stop. The grievance of the petitioner is with regard to withholding the no objection certificate / no due certificate in respect of a cash credit account maintained with the respondent to bank on the ground that there is a complaint involving rupees 20 only.
Yes.
Full stop. It is submitted that though a loan facility was availed by the petitioner, the same was repaid in full. Whereafter, some cyber fraud was committed involving rupees 20 by some third party without the knowledge of the petitioner. Vera, let notice be issued, returnable on 6th of April 2026. SS Roy, Mr. Roy, Union of India. SS Roy CGC for 1. Extra copies, 2 by speed post with AD. Steps within 2 days.
My lord, senior is in leg in court number 1, my lord. Kindly pass over for time being, my lord.
Who's your senior? Barua?
Enze Burwa.
Okay.
All right.
May please. My lord, in this case, my lord, the petitioner are the residents of Prohibitions district, my lord. During the year 2017 to 20, my lord, number of development schemes were sanctioned in favor of their village, my lord. But none of this scheme was executed, my lord. And without executing any work, my lord, the amount has.
You don't have your ward representative. You have. Don't you have a ward member?
No, my lord. I am the villager, my lord.
Huh?
Petitioner are the villagers, my lord.
Understood. You do not have a ward member from your village. Why don't you approach him? He's your representative.
My lord. Complaint was.
Why is the member elected from the ward? To look after the development of that ward. Now you say that your village has been neglected.
No, my lord. Schemes were sanctioned, my lord, but without executing any work, amount has been misappropriated by the.
Schemes were sanctioned?
Sanctioned, my lord.
But no works done?
No work done, my lord.
Madam, allegations are serious. Heard. 3. KHMR Chaudhary, Learned Counsel for the petitioners. Full stop. As per the facts projected, the petitioners are residents, DNTS, of villages Hatkhala and Mulagram of Asimganj Gaon Panchayat under the Patharkandi development block in the district of Sribhumi. Full stop. But those financial year 17 to 2020,
Yes,
how do you come in 2026?
No, my lord. sanctioned in the year during 17 to 20, my lord, but works were executed, normally execute 2-3 years later, my lord.
But 20, the sanction was there, you come in 2026.
At that time, COVID was there, my lord.
Thereafter, COVID is continuing to 6 years.
Yeah, no, my lord. Several complaints were filed, your lordship will find. And
We're not going to entertain this.
my lord, kindly see the
This is not having any bona fide.
No, my
I'm
lord,
not going to
kindly,
entertain
kindly
this.
see the last annexure, my lord.
Page?
Page 37, my lord.
Yes.
Complaint was lodged even to the Director of Vigilance and Anti-Corruption, my lord. And Director of Vigilance and Anti-Corruption forwarded the complaint to the Commissioner of Panchayat, my lord, to take necessary action, my lord. Still no action was taken, my lord. Your lordship kindly.
From this also, it's more than 1.5 years.
And in the meantime,
So. Full stop. During the financial years 2017-2020, though various schemes were granted for developmental activities of their villages, such schemes were not executed, for which the petitioners had lodged complaints. However, no action has been taken. The Learned Council has also drawn the attention of this court to the communication dated 29/7/2024 issued by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, page 37. Regarding the investigation. Full stop. However, no concrete steps have been taken. Let notice be issued returnable on 6th of April 2026. Madam, for 1, 2 and 2. 1, 2 and 4 also. 1, 2 and 4. P Thapa on behalf of S. Dr. 1, 2 and 4 and PK Medi for respond number 3. Extra copies. The Learned Council for the respondents have, however, raised an objection on the ground of delay and laches in approaching this court. But Mr. Chaudhary, those persons have not been made parties. How do you proceed?
no, my lord, there are so many. My lord, if any investigation is made, my lord, then picture will come, my lord.
That will come because your complaint has got certain names. Item number?
My lord, lordship, the earlier, my lord, order of this honorable court, direction
Yes.
is given to make the accommodation in the ground floor, shifting the toilets. Accordingly, we have filed the representation also, but they don't comply to it. Then we file the contempt, but your lordship is this time, but that is why liberty is given to agitate this matter and fresh requisition. That is why we have filed this. So now we apprehending that some outsiders will be accommodated. That is why 2 years they.
Well, why don't you settle it? It's been long pending.
Only regarding fees vendors. There are no fees vendors.
Now that was settled and that direction, my lord, page 67. With direction to approach and that.
Heard 3 MJ Borwa, Learned Council for the petitioners. Full stop. The petition has a checkered history and the present approach is on the aspect of allotment of space to the petitioners who are the victims of a fire which had occurred in the market in the year 2018.
The mileage
18, I think.
89, 22, 22
In the year 2018.
89.
In the year in the 2000.
No, 1989, my lord.
1980. Lordship, can you see the pair? Pair is only for.
Occurred, which is fire victims occurred in the market, in the analogy. Yes.
No, Lordship, see, the pair is only for this. Institution is trying to give accommodation to a persons who are not in existence. Fees vending only on the ground floor. There are no single fees vendor now.
My lord,
They are from 2014 onwards, they have not taken out.
Sri S. Bora, Learned Standing Council, GMC, has however submitted that the petition is not maintainable in as much as there are no fees traders in the ground floor of the building in question
They have not taken out license since 2014.
my lord,
since the year 2014.
my lord, it's,
Okay, we'll issue
this
notice.
is, my lord, mezzanine floor allotment is given.
Let
That-
notice be issued returnable on 6th of April 2026.
All the rest.
3 S. Bora, Learned Standing Council, GMC, accept notice on behalf of all the respondents, extra copies.
My lord, one protection, if they accommodate the outside, they're still then, status quo may be maintained because they tried to.
Are you giving to any third party?
Both third party will come because.
But that observation may be.
Sri Barua, the Learned Council has paid for some interim, praised for an interim order. Para? Sri Bora, the Learned Standing Council has submitted that there is no proposal to allot any space to any third party
Fees vendor.
for fees vending.
That
For
is
fees
for
vending.
fees vending.
Okay.
Fees vending means, that is allotted by mayor in council in ground floor. They, if
Okay, let us see. Next, 6th, please give extra copies to Mr. Bora. Okay. Next.
May it pleases your lordships. My lord, petitioners are the victim of acid attack. And they have received amount of that I have already stated, lordship, compensation as for the victim compensation act. And lordship, they are entitled to additional compensation of rupees 1 lakh each, lordship, as per the notification of the Government of India, lordship, which I have annexed.
Not paid.
Not paid, lordship, page 53, annexed 3.
Okay. Heard Ms. D. Ghosh, Learned Counsel for the petitioners. Full stop. The petitioners, who are 3 in numbers, are victims of acid attack, which took place on 21/3/2017, and for which police case was also lodged. Full stop. While it is admitted that certain compensation has been received, the compensation which is admissible under the notification dated 9/11/2016 of the Government of India has not been paid. Let notice be issued, returnable on
Lordship, similar interim prayer also is being passed by the honorable coordinate benches, lordship, of 1 lakh rupees.
interim means
Interim prayer of rupees 1 lakh, which I had prayed, lordship, as per this notification, lordship. And petitioner number 1 also is seeking for her medical treatment, lordship. And in this case, she has received interim compensation of rupees 1 lakh as per this notification, lordship.
now where is the direction?
And in the subsequent, because the instruction was being sought for and there was.
Oh, that is it. We were only giving notice. We can consider on the next date.
Yes, lordship.
Okay, last okay. Issue notice, returnable on, we'll give a short date.
Yes.
Are there any private respondents? No.
No problem.
On 6th of April. Union of India, who will be taking? The Union of India? RDB. CGC 1. Then Chief Secretary. PK Medhi 2 and 6. Then Health, Madam. 3 and 4 S, Miss S. Sharma, 3 and 4. What about 5, Finance? Finance? Bodola, your finance? No. Is he there in the court? H earlier for 5, sending counsel and 6. This you have already taken, Deputy District Commissioner? Yes, okay. Extra copies. Full stop. The prayer for, is there any interim order? Interim prayer? The prayer for interim order would be considered on the next date.
Deeply aware.
May it please, your lordship.
But your interim prayer will be the final prayer. What will be the?
Lordship, I have prayed for treatment of petitioner number 1 because she can't have solid food. That is her medical assessment.
So that will be the final prayer. You are only requiring 1 lakh extra as per the government notification.
No, her treatment also free of cost as per the Honorable High Court's division bench order, Lordship.
So as an interim, what do you expect in an interim?
Interim only 1 lakh rupees each.
So that without adjudication, that is your claim.
Lordship,
Now there are factual aspects. Suppose
yes,
there are
Lordship.
factual disputes. What will happen?
Already they have received, because factual aspects, Lordship, she has received compensation under the Victim Compensation Act of Assam. She has received petition.
Madam, those are your projection. We do not know.
And
we are at the stage of issuance of notice.
yes, Lordship.
See, interim prayer is something which,
And
if not given, something is going to happen. Now, this is your final prayer.
this
1
is
lakh rupees.
1 lakh rupees each, Lordship, and her medical treatment. That is my final prayer of the petitioner number 1, Lordship.
Okay, let us see. Not a case of interim. Maybe we can pass final orders if they are not disputing your projection on facts.
Yes,
Not
Lordship.
only 1 lakh, you may also be entitled for the treatment cost
Yes,
in
Lordship.
accordance with law. Okay, next.
In connection with the Honorable Court's division bench order, Lordship.
May it please, your lordship. Lordship, the land of the petitioner has been acquired.
Item number, madam.
24.
Your land has been acquired.
Land has been acquired for widening of the NH 31 in way back in the year 2006, but without issuing any mandatory notice as per the National Highway Authority Act. No compensation has been paid till date. The petitioner visited the office of the DC repeatedly and asked for compensation.
But it was acquired in 2006.
No notices were sent. No notices were issued to the
But
petitioner.
if your land is acquired, can you say that I do not know about it? It's been taken away. When was possession taken over?
Lordship, the petitioner had no knowledge. In the year 2019, the petitioner came to know, and thereafter.
Your land has been taken away. You do not have knowledge. What is this kind of a projection?
Lordship, even
Your
the
property taken away by somebody you are not aware for 13 years.
compensation has also not been released.
No, that is not the question. When have you come to the court? Acquisition which has taken place in the year 2006.
6.
You have come after 20 years.
The notice was issued only last year.
What notice?
Annexure 6, page 42.
42. What is this notice? 42.
Page 42 is the type copy. The main annexure is at page 44.
This has been approved, but paid or not? Not
No,
paid.
not paid.
Well, tell us then. You have to highlight on this aspect. Your ARI, VRI,
Virai.
heard Ms. VRI, Learned Counsel for the petitioner, who is aggrieved by non-receipt of land compensation amount, full stop. It is contended that though the land was acquired in the year 2006, comma, the process of payment of compensation started long thereafter, and in this regard, reliance has been put to a communication dated 1/8/2025 issued by the Additional District Commissioner, Nalbari, directing the petitioner to submit certain documents and particulars. Full stop. It is submitted that even have you fulfilled this?
Lordship.
Where have you stated? after this notice of August 2025,
Lordship,
after this notice of 1/8/2025, this notice directing you to submit certain documents, have you submitted those documents?
as per the knowledge of the, as per my communication, it has been submitted, but we have not.
Where have you stated?
It has not been stated.
You have to state it. If you have not fulfilled your discharged your obligation, how did they proceed?
Lordship, this notice was issued after the petitioner persuaded the officers.
Thereafter, you need to file this application, file these particulars. Have you
Lordship,
done it or not?
I will seek information, communication.
Madam, why do you do half-baked kind of things? State it and get an order. কি করলো স্যার? To certain how it have you checked in the petition? Have you checked? Do it again. Where is that?
Para 9, I have made development about this notice.
Notice, para 9, page
Page 8.
8.
That's it.
You have not said anything. It is, however, not discernible from the petition as to whether the petitioner had submitted the required documents and particulars. Footstop. At this stage, Ms. Rai, the learned counsel, prays for some time to obtain instructions and file additional affidavit. Footstop. 1 week. List on Wednesday next.
That's it.
List as requested. List on today is 9th. We'll have it on 18th, madam.
That's it.
18th. You get a week's time. File it.
Deeply obliged.
Let her file it, then we can issue notice.
56. Lord, the land has been acquired and taken possession without paying compensation, my lord, in violation of section 38, my lord. Yes, for construction of dike, my lord, in filling the water. And the deputy commissioner has asked the water resource department to pay the amount, my lord. That pays 24, my lord.
When was the acquisition done?
24, my lord.
Heard 3G and Sahola learned senior counsel for the petitioner assisted by madam. Your name?
K. Bhattacharya.
K. Bhattacharya for the petitioner, huh? The grievance of the petitioner is non-payment of acquisition amount for non-payment of compensation amount for acquisition of land.
Land and damage of, my lord.
Land and also damages to tea bushes. Footstop. Let notice be issued, returnable on 8th of April 2026. Revenue, madam. Bordolo, 1. 1, madam, only? The DC at Deputy Chief Engineer, I think what?
3 and 4.
2 would be Mr. Roy, SS Roy. 3 and 4 on behalf of RM Das, madam. Give your name, okay? Your name to লিখে লব, huh? Extra copies.
May I please, Your Lordship, also
Yes.
this is a case wherein we have filed the writ petition against the rejection of my refund application. Lordship, I am, Lordship, in the business of construction of my guest house, own guest house for commercial purpose. So Lordship, under section 16 of the CGST Act, I was eligible to get ITC. But Lordship, section 17(5)(d) of the GST Act puts an exception that in case you are building an Lordship immovable property, if you are building an immovable property, you are not eligible to get ITC. But there is an exception to that exception that if it is a plant or machinery, then Lordship, we are eligible to get the
If it is a
plant or machinery.
plant or machinery.
Then we are eligible to get the ITC.
But guest house, is it a plant or machinery?
Lordship, the Honorable Supreme Court has said that if you are building it for commercial purpose, in safari retreats, Lordship, the judgment has specifically held for Lordship retreat centers, as well as it has laid down a Lordship this one, Lordship, a law that what is the meaning of a plant. So Lordship, that meaning of plant which has been laid down under the Lordship safari retreat judgment, that has to be Lordship carried out by the central GST authorities when we filed the refund application. That has not been done. Lordship, I'll just take your Lordship to only one paragraph of the safari retreat judgments.
Yes.
Lordship, after that, they have made amendment also to the act Lordship against the safari retreat judgment. They have made that plant or machinery. They have made it plant and machinery. Lordship, Lordship, the judgment. Lordship, I have annexed the judgment, which is at Annexure 4, page 77.
No, if it has been made disjunctive by replacing or with and, then there has to be both.
Lordship, in my opinion, Lordship, in my humble submission, that has not made any Lordship. Lordship, it has not affected the judgment, because after that also they filed a review and that was dismissed. Review of the judgment after making the amendment, they filed a review before the Supreme Court, and Lordship, that was dismissed. That issue has to be decided by your Lordship.
This new amendment,
Yes, your Lordship.
if unless it is put to challenge, amendment came later after the safari retreat.
After the safari retreat judgment too, and
If and is there, still there, and if and is not interfered by any court, so it will remain in the statute book. Plant, and first we'll see safari whether a guest house can be treated as a plant.
Yes, your
number
Lordship.
one.
Yes, your Lordship.
Now the additional hurdle of yours is that there is a requirement to have plant and machinery.
Machinery. Now the amendment has come,
Okay.
plant and machinery. Lordship, what will be the effect of that amendment? That has also to be seen. That will be examined by your Lordship in this case, Lordship. At this
No,
stage,
but see, examined, if it's a disjunctive and a machinery, guest house cannot be said to be a machinery. Whether it be a
not
plant or
machinery,
not,
okay.
that is also a question, but that you say
that
has
to
been
be
answered.
decided. That should be decided by them, Lordship. This is what the court has held. The Supreme Court has held.
Let us see that first.
Lordship,
Retreat.
Lordship, the section, Lordship may kindly see page 127. That is the operative part.
127.
Thereafter, I will take your Lordship that where it has been held that it is a plant. 127, Lordship. Paragraph 65, Lordship. Lordship. Paragraph 65. Lordship, some of our conclusions can be summarized as under. Lordship,
Yes.
the challenge to the constitutional validity of clauses C and D of section 17(5) of the CGST Act is not established. Expression plant or machinery used in section 17(5)(d) cannot be given the same meaning as the expression plant and machinery defined by explanation to section 17. The question whether a mall, warehouse, or any building other than a hotel or cinema hall creator can be classified as a plant within the meaning of the expression plant or machinery used in section 17(5)(d) is a factual question which has to be determined, keeping in mind the business of the registered person and the role that building is playing in that said business. If the construction of a building was essentially for carrying out the activity of supplying services, such as renting or giving on lease or other transaction in respect of the building or part thereof, which are covered by clauses 2 and 5 of Schedule 2 of CGST Act, the building could be held as plant. Then it is taken out of the exception carved out by clause D of section 17(5) of section 1 of section 16. Functionally, test will have to be applied to decide whether a building is a plant. Therefore, by using the functionality test in each case on facts, in the light of what we have held earlier, it would have to be decided whether the construction of a immovable property is a plant for the purposes of clause D of the section 17(5). So, final adjudication has not been made, but plant has been had. What is the meaning of a plant in respect of immovable property has been
But it has been clarified that it will all depend on the facts.
Depends on the facts, Lordship. Now, I had filed an application of refund on the basis of Lordship safari retreats. Lordship, my grievance is that they have rejected my refund application without going into the safari retreat judgment. And Lordship, in fact, it can be disposed of by stating that they can apply the safari retreat judgment as well as the amendment and see that whether if the same is not applied, Lordship, I am not even able to. Lordship, I'll have to depend on their affidavit to establish what exactly is my case. They will, Lordship, my only Lordship, this is that prayer is that they may again reconsider my refund application in the view of Safari retreat judgment as well as the subsequent amendment. Whether my
Let us issue notice at this stage,
Yes,
but
correct.
we are not very sure. Heard Miss Anne Haveli, Learned Counsel for the petitioner or petitioners, how many of you are there?
Lordship, one petitioner, Lordship, partnership firm.
Petitioner. You've written petitioners on the synopsis.
So sorry.
Petitioner who is aggrieved by an order dated 10/12/2024 issued by the respondent number 3, whereby the refund paid for has been rejected. It is contended that the petitioner is running a guest house,
Commercial guest house.
commercial guest house, and their refund is substantiated, and their claim for refund is substantiated by the judgment of the Honorable Supreme Court reported in 2024 SCC online SC 2691 bracket Chief Commissioner of page 77 se dekh lijiye naam para a perusal the Learned Counsel has also informed that subsequently there is an amendment of the relevant statute whereby plant or machinery inverted by plant or machinery inverted has been replaced by inverted plant and machinery. Full stop. Para. A perusal of the conclusion arrived by the Honorable Supreme Court, which has been called out in paragraph 65 of the said judgment, would, however, indicate that each case has to be considered on depending on the facts and circumstances. Full stop. Para. Be that as it may, let notice be issued, returnable on 6th of April 2026. Union of India. Ms. M. Das on behalf of S Committee for 1. And Madam, you are for whom? CGST. On behalf of Kyle. Dr. B.N. Gogoi. Okay, what is your name? Give your name. Miss So-and-so on behalf of Dr. P.N. Gogoi for 2, 3, 4. CBDT I said 5 also, I think. 5. And till 5 and H. Barwa for 6 extra copies. Okay. You try to file your returns. This matter will require some deliberation. Madam, you also examine.
Lordship, many high courts are examining this now, Lordship. It is pending before many high courts. I'll bring it the next day.
May I please, Your Lordship? In this case, Your Lordship, the son of the petitioner has murdered by the accused person, namely Dinesh Rao, Your Lordship. And accordingly, the accused person has already convicted, Your Lordship, by the session court of the Surat on dated 14/2/2022. But there is no recommendation has been made for compensation as per the Assam Victim Compensation Scheme 2012. Therefore, after the conviction, Your Lordship, petitioner filed an application before the District Legal Services Authority of Jodhpur on 22/8/2025, Your Lordship, but which has been not considered.
Heard. This item number. Heard Sri S.I. Akand, Learned Counsel for the. What is the next case? Same.
No, Lordship.
Next is different.
As per the Assam Victim Compensation Scheme 2012.
No, you have another matter?
No, there is natural calamity. Your
Okay.
Lordship.
Sri S.I. Akand, Learned Counsel for the petitioner who is aggrieved by non-payment of compensation under the Assam Victim Compensation Scheme notified notified on 18/10/2012 and amended on 1/2/2019. Full stop. It is submitted that the son of the petitioner was killed for which a police case was registered, culminating in the conviction and sentencing of the accused person. Full stop. The petitioner had accordingly filed application for payment of compensation, which has not been given. Para. Let notice be issued. Returnable on 6th of April 2026. Woman political, yes. J. Hendik for 1,
1, 3, and 4.
1, 3, and 4, and your Chauhan on behalf of R.S. Chaudhary, standing counsel for 2. Your full name? R. Chauhan, huh? On behalf of Miss R.S. Chaudhary, standing counsel, Asalsa, for 2 extra copies. Okay.
So 29, Your Lordship, the husband of the petitioner had been expired due to natural calamity, Your Lordship.
What is the natural calamity?
If your natural calamity is storm, Your Lordship.
Hmm?
Storm, Your Lordship.
Storm.
Yes, Your Lordship. As per the notification, Your Lordship, if Your Lordship will find at page 49, Your Lordship, the state government has been notified the storm is a natural calamity, Your Lordship. 41, Your Lordship.
Okay. Part 3 S.I. Akan Learned Counsel for the petitioner, who by means of this application has made a claim for payment of compensation under a payment of ex gratia.
Yes.
Under the relevant government notifications pertaining to death by natural calamity. Full stop. It is contended that the husband of the petitioner had died in a storm occurring on 19/3/2024 when a big branch of a tree fell upon him. Full stop. Para. Let notice be issued. Returnable on same, huh? 6th. Revenue. PR Monto 1. Finance. R. Barua on behalf of Nayak. To RM Barua, miss. Then J. Hendik for 3, 4, and 5. State Council. Union of India, A.K. Datta. TGC. Extra copies.
I'm deeply obliged.
May it please your lordship. My lord, before I start, my lord, I will admit one fact, my lord, that the order that I challenge, my lord, there is a provision for appeal under the statute. But in spite thereof, my lord, I crave this honorable court's indulgence for this 226 jurisdiction, my lord, on based primarily on 2 counts. That the impugned order has been passed under the powers of section 73. But there is a brief facts just after the synopsis, my lord. It gives a complete picture of my case. My lord, what I was saying is that the impugned order has been passed in exercise of section 74 of the CGST. And I do not say that on merits this honorable court will exercise its powers. But if I can just point out that the jurisdictional error has been committed. There was no jurisdiction on the part of the authorities to exercise powers under section 74. At the most, it could have been an exercise at all necessary under section 73, which would have placed me in a different situation altogether. Now, having said that, my lord, section 74 prejudice is caused to me that provides for 10% of pre-deposit for an appeal, and section 74 would not have been invoked. That I will show in a little while, so far as the merits is concerned. So far as section 73 is concerned, if exercise would have been done and correctly so under section 73, I could have availed my statutory appellate right, my lord. Now, so far as section 74 is concerned,
You are referring to which act, madam?
of the CGST Act.
This is the one for the subdivision.
My lord, I have a book. If
We have. Let us, that will work in it.
Goods and Services Tax Act. Section 74, my lord.
Yes.
74 and 73 are more or less similar, but there is a basic difference, my lord. 74 is determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts. This is section 74. It will apply when there is fraud, willful misstatement and suppression of facts. And if I may take my lord to say section
No, those are or.
or
That is one of the aspects that if there is any willful misstatement or
any willful
but there are other facets. Determination of tax not paid, number one.
yes
Or
short paid
or
or
that means for not paid you can proceed, or for short paid, or erroneously refunded, or tax input ITC
wrongly
availed or
or
utilized by
reason of
fraud or any willful misstatement of suppression of fact.
my lord, I am obliged. Exactly, my lord. And my lord, may kindly take section 73.
Yes.
It's determination of tax
Not paid
or short paid or erroneously refunded or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression of facts. What I was trying
So this
to
is the difference between 73 and 74.
Yes. Now, in my respectful submission, the impugned order, it has to determine whether there was jurisdiction, there was fraud or any willful misstatement or suppression of facts to invoke 74. So without that preliminary finding, my lord, this 74 could not have been proceeded with. It could have been initiated and this jurisdictional fact ought to have been decided first, but this has not been done. On this count,
Let us see the impugned order.
that is at page 41.
41.
My lord. Annexure B. My lord, on this, it's a long order. If I may just from page 43 onwards, it talks on whatever foundation it laid for invoking the section 74 jurisdiction. In para 1.1, may I read it, my lord?
Yes.
Intelligence has been gathered to the effect that the said noticee has availed and utilized ITC on the basis of tax invoices without receiving the goods or services or both. During course of inquiry, it came to light that the said noticee had been receiving coal from C so and so. I 4 lines, 5 lines I skipped, my lord, the names. The above mentioned suppliers of coal were registered in the state of Meghalaya. Now, this is important. To ascertain the veracity of the claim of the said notices, correspondence was made with the Director Mineral Resources Shillong, white letter number dated 25th August 2022. The Director of Mineral Resources Shillong informed that no mineral transport challan has been issued to the aforesaid persons. Now, my lord, thereafter, my lord, 1.2, further inquiry revealed that more persons are involved in issuing fake invoices. So, further correspondence was made with Director Mineral
Resource Meghalaya regarding all 4 coal suppliers mentioned in para 1.1 who supplied coal to the notices. The last sentence, my lord, in absence of issuance, mineral transport of Chalan, nobody can transport Meghalaya coal. That's, my lord, that is correct, my lord. 1.3, it talks about verification of e-way bills, and this para, my lord, states that there was absence of the recording of e-way bills in the toll plaza. Now, my lord, 2.1 talks about summons issued to the suppliers, my lord, and my lord, I may point at one thing, because this is ultimately what para 4.0 at page 49, my lord. Accordingly, may I read, my lord?
Yes.
Accordingly, Sri Mahesh Agarwala, proprietor so-and-so, was called upon to show cause before so-and-so. Then, if we may move to 5.0 at page 50. I am pointing out relevant ones, my lord,
Yes,
which is
yes.
against me and which is for me also.
Yes.
The notice is submitted the reply to the show cause notice by letter dated so-and-so, which is reproduced verbatim. My lord, may just see clause 2, my lord, that I have taken input tax credit on fulfillment of following conditions: receipt of invoices, receipt of goods, report of invoices by the supplier in monthly GSTR form 1. Then if we move to the 3 that I have received goods and paid the onward liabilities. Liabilities have been paid according to our assessment. Page 51, my lord, 4. That I have dispatched the goods via railway, of which I have attached railway receipt with details. The mineral transport challan are being issued to the supplier mentioned in the letter, and a copy of which has been attached with this letter. That supplier provided goods to us from 12 mile to 15 mile and Dina Dubi. Coal was transported from there. Also, the rake point at Kamlajari is very near to this location. The truck driver is totally dependent to bring goods to rake point, my lord. He may have used other route to avoid all toll charges. We used to receive the goods always at the rake points. Also, we had no idea which route was taken by the truck driver. That as per 3.1 of your notice, we have complied all the 3 conditions mentioned before availing the ITC. Thereafter, my lord, may this 6.1 is absence of mineral transport challan. If I may just take the second.
There are materials we have just seen.
Yes, I will show, my lord.
We have read this.
Yes.
We have read this.
Wherein, my lord, transport
There are
challan.
findings also.
Yes.
There are material. What do you say, Mr. Jain?
They have not availed 107.
But Madam, what about your interim prayer at page 26? You have also prayed for allowing you to file an appeal without saving the limitation.
My lord,
Your
my lord, if I am able to satisfy this honorable court, that section 74, in view of the MTC challans, the certificates given by the department itself were given, the railway receipts were given. Section 74, if at all to be exercised, the preliminary issue had to be framed as to the jurisdictional fact. Thereafter, it could have proceeded. If the jurisdictional fact would have been
no,
decided
you come to
against
page 26. What is this prayer?
my lord,
Direct the respondents to allow the petitioner to file the appeal.
my lord.
Where petitioner undertakes to furnish reasonable security. You're making a concession here.
My lord, this my lord, alternative prayer I have put, my lord, alternative prayer, but
No, there is no restriction for this. You need not come to the High Court.
correct.
It's a statutory right.
That's correct. My lord, the 107 actually will not come in because section 74, that jurisdictional fact has not been decided. If I have been able to satisfy this on
No, Madam Goel, that is what is troubling us. This is your specific prayer to allow you to file an appeal.
Yes.
If you are making a challenge, why do you make this prayer? It is not even an alternative prayer. If you fail here, automatically nobody can bar you from.
That's correct.
But you said it
That's
should be
correct.
allowed. You are allowed.
That's that's
allowed.
correct. That's correct.
And
That
the order which is put to challenge,
my lord.
you cannot say that it's a cryptic kind of an order. There has been discussion on the aspect of fraudulent activities on at least 5-6 occasions.
My lord, that I will show that it is not correct because I have at page 52, my lord. I was just about to place that. Page 52, my lord. I
Yes.
satisfy, my lord. Subsequent to the department's allegations, we took proactive steps to verify the authenticity of the mineral.
See, these are all satisfaction arrived. Now, whether these are correct or not, will come into the realm of disputed questions.
My lord,
which
that
you-
jurisdictional fact, my lord.
Now, which you will have a better forum to argue in the appeal.
My lord, in the appeal,
Now, can we go into the adequacy of the reasons signed, or we'll go by the reasons?
my lord, in
Tertiary jurisdiction.
my lord,
If
in
your
my
lordship sees
respectful
the
submission,
prayer
my
number C at page 25, they have prayed that each will read in the nature of mandamus directing respondent number 3 to entertain the petitioner's statutory appeal without insisting on mandatory pre-deposit or upon such reduced deposit security as this.
That is your main prayer.
They have made this prayer.
yes,
that
I
they
have this
they
prayer.
will be allowed to
I'm not,
make an appeal.
I'm not,
This is the mandate of the law. They have to pay 10% of the disputed amount. That is there in section 1076.
my friend may just allow me. My lord, I will just
And in
point out.
that case, C is there, and requirement of statute, we cannot just.
That's very correct, my lord.
Overcome.
Exactly, I want the requirement of
Well,
statute, my lord.
you withdraw this, madam. Why do you unnecessarily
My
get an order of this court?
my lord, that page 52.
You'll be at liberty to make out a case that 74 is not will not come into operation. There is no fake transaction. Everything will be appealed. Everything will be open for you.
My lord, so far as the jurisdiction part is concerned, 107 does
No,
not
in
get
view of
me.
prayer C, we are not even going to that aspect. We did not even notice C. We are noticing your interim relief to allow you to file appeal. Now C, you have a specific prayer that you need to given.
My lord, that is my lord.
And the requirement of deposit 10% is a requirement of statute.
That is the
My,
mandate.
that is why I have. That is why I'm.
What
invoking-
powers do you have?
My lord, for this, my lord, on this 10%, my lord, that is why I said section 73 does not allow 100% penalty. Section 74 allows 100% penalty, which they have invoked incorrectly, my lord. There has been a jurisdictional error,
Now,
my
what
lord.
is so special about your client that 10% deposit has to be
Waived.
waived? What
my
is
lord.
so
There is
special?
reason, my lord.
Have you make out an exceptional case?
My lord,
Sorry.
my lord, may kindly bear me for just
Now we have seen your petition. We have given you
my lord, another half a minute.
what half a
my lord.
minute? We'll give you 1 minute.
I'm
We've seen the order.
I'm
Madam, you
grateful.
better withdraw this. Otherwise,
I'm grateful, my lord. Just I'll point out
yes, go ahead, Learned Counsel.
minute, my lord.
Yes.
Half a minute.
Yes.
I'm grateful, my lord. My lord, actually, I have stated in my petition why I am seeking a waiver. If at all I have to go to appeal, my lord. The state authorities, my lord, I am facing around 5 multiple proceedings. And in one of the proceedings, my lord, all my property documents, etc., have been seized by the ED. And I am unable to liquidate my property also to arrange for the pre-deposit. So I pray, my lord.
A further ground for the court to reject your petition.
My lord, may I?
This will be a further ground.
My lord, may I make a prayer in this situation, my lord? Let me be granted liberty to withdraw but with liberty to come back, my lord.
You withdraw with come back. Why? What liberty? You cannot come back. It's a specific prayer in your writ petition.
My lord, but my prayer is, my lord. So far as my prayer is concerned, my lord, my prayer is that.
See, madam, if you are insisting on 73 and 74, we have to record some prima facie satisfaction that there are materials to show that 74 would also come in. If those observations are there, it might be difficult for you.
It will affect me.
Because we have seen the long order. You may be correct in contending that these are not factually correct, but those have been recorded, not in one occasion. We have marked it.
My
several
lord,
occasions.
page 52, my lord, may say.
Yes, 52 onwards,
Page 52?
6.2, come to 6.2, official email.
Before 6.2,
No,
my
no,
lord.
if come to on the fake invoices, department alleges, see the language used.
Yes, it alleges.
Yes, language, he is acting,
It has to be established by.
madam, he is acting very neutrally, he is the adjudicating authority, I am speaking on your behalf.
My lord,
He has not come to a finding. He is the adjudicating authority. He says, department alleges that upon verification of the EUA bill submitted by us, they were found to be non-existent. Specifically, the official e-bill website says, no EUA bill found, message for the vehicle numbers mentioned in the EUA bills for the relevant is a check. Then he goes, a check of the vehicle registration numbers crossing the toll bill between Shillong and Guwahati reveals no records available.
My lord, that is.
These are findings.
That is purpose to the record on the papers and records, my lord. These documents are.
And
on
you were
record, my
given,
lord.
you were given,
It is filed, my lord.
you were given personal hearing.
Yes, and I produced those documents. Those which the adjudicating authority says it is not that, it is on record, my lord. It is on record, and this just before 6.2, my lord, may kindly see page 52, the first previous two subparas, my lord. It talks about the documents being available on record. It is available, my lord, and that is why I say that it is perverse, my lord. My lord, when the documents are there and it is not considered, my lord, and there is no finding given as to why those documents are not
What is
considered.
prayer see, madam?
My lord, if my lord does not see those documents and does not read what I have said.
What is paragraph C? Prayer C.
That I
Prayer
have.
C.
Prayer C, yes.
Issue a writ in the nature of mandamus directive response number 3 to entertain the petition of statutory appeal without insisting on mandatory prerequisite.
I make these alternative prayers, my lord.
This is not alternative. This is not alternative. This is not the alternative. And even an interim prayer is a direct response to allow the petition to file appeal.
My main prayer is to set aside the impugn order. But in alternative, I say.
What is a main prayer? What is an alternative prayer, madam? Let us understand from you. If you have not understood all these years,
My lord, that is
what is an alternative prayer? If
for-
you are marking A, B, C, D,
My lord.
is C become an alternative prayer or D becomes an alternative prayer? Unless you say in the alternative, if A and B are not granted, then I come to C.
My lord, that is
It's only numbering.
That is a submission I'm making, my lord. My lord, may I pray for withdrawing, my lord, with liberty, my lord.
Liberty will not be granted.
My lord,
Liberty will not be granted.
Lord, if
Liberty will be granted only when you come strictly in accordance with law.
my lord, it may be struck off, my lord, that prayer.
Which-
That prayer.
How can we struck off? That's
See,
your
my
prayer. Nobody advised you to make this prayer.
My lord, considering, my lord, I'm aware that there is a provision for appeal, my lord, and I'm invoking 226, my lord. Being aware of that fact, I kept this, my lord. My lord may not shut me out, my lord.
Heard Miss B.S. Goyal, learned counsel for the petitioner who has put to challenge an order dated 39/20/25 passed under section 74 of the CGST Act confirming a demand of rupees 7,59,52,817 with interest and penalty on the allegation of wrongful availment of input tax credit within bracket ITC. Full stop. Also heard Sri K. Jain, learned counsel appearing on instruction of Sri S.C. Kyle, learned senior standing counsel CGST. Full stop. Para. It is contended by the learned counsel that there is wrong invocation of section 74 of the Act, which essentially requires misstatement and suppression, which is not there in the instant case. Full stop. She has also submitted that though there is a provision for preferring appeal, comma, the said provision is onerous inasmuch as it requires pre-deposit of 10% of the amount involved. Full stop. Para 3 Jane, the learned counsel for the respondent has however submitted that the impugned order is a reasoned one, wherein there is a specific finding on the aspect of misstatement and suppression of material facts, which is in connection with with submission of fake bills, fake documents, in fake invoices. Full stop. He has submitted that there is a specific finding that there was no e-way bill in the from the records of the toll plaza between in the route from Meghalaya to Bongaigaon. You are in Bongaigaon. Where are you? Bongaigaon. We didn't make it Assam. Meghalaya to Assam. We didn't make it. Meghalaya to Bongaigaon. We didn't make it Assam. Full stop. Para. A bare perusal of the impugned order dated so and so would reveal that the same has cited reasons for coming to the conclusion. Full stop. The order also appears to have been taken into consideration the relevant factors. Full stop. It is right law that while exercising certiorari jurisdiction, this court is not required to go to the adequacy and sufficiency of reasons, and unless the reasons are absolutely perverse to the perverse and or perverse or been put or accentuated by malafide. Full stop. Para. This court has also noticed that there is a specific prayer for allowing the petitioner to prefer a statutory appeal without insisting on the mandatory prerequisite. First of all, for ready reference, the relief prayed for is extracted here in below. Para. In the considered opinion of this court, no such direction cannot be granted, more so when the requirement is a statutory one and no extraordinary circumstance has been able to be demonstrated in the said case. Full stop. Para. In view of the above, writ petition stands dismissed. Full stop. It is, however, made clear that the observations made in this order are tentative and will not cause any prejudice to the petitioners if an appeal is filed and the same is to be adjudicated strictly on its merits.
I'm grateful.
Cancellation of GST registration. Similar
Yes,
matter
madam.
lordship fixed on Monday.
Monday, some matters are fixed.
Yes, lordship 16.
Madam, you will take instructions. Okay. Heard Miss Anne Havelia, learned counsel for the petitioner who is aggrieved by cancellation of the GST registration of the petitioner right order dated 8/11/2024. She has informed that similar matters are fixed for consideration on Monday,
16. 16.
16th. Okay.
It can be taken up on Friday also, lordship.
Huh?
I have no objection. This matter can be taken up on Friday also.
Madam, you have instructions. No, is it covered?
But it's covered by the judgment, your lordship's
We are
judgment.
remanding
Where is
back
it?
for a fresh
Yes, sir,
consideration.
first question. Revocation.
And we'll have it on Monday itself.
Yes, sir.
Do you have a number?
Lordship. Case number 1269 of 2026.
Being similar matters. accordingly release this matter on Monday along with WPC 1269 of 2020.
1269 of 2026.
1269 2026. Please give them extra copies, okay?
Sure.
Let extra copies of the writ petition be served upon Miss so-and-so and Miss so-and-so to enable them to obtain instructions.
Sure.
We'll try to dispose of. Ask Dr. Gogoi to be ready. Okay.
Sure.
32, yes, what is this?
I'm telling the so cause notice is placed 20, my lord, whereby my GST has been suspended. What is the so cause notice that does not contain any particulars, only a line, my lord, non-payment of demand of tax under section 73. My lord, section 20, rule 21 and section 29 governs the cancellation proceeding. It does not provide any such reason, my lord, for cancellation, my lord. And lords.
My lord,
No, not cancelled. It's been suspended.
Suspended, my lord.
Not cancelled.
Not cancelled, suspended, my lord. For the purpose of
issue notice at this stage.
I have one prayer, my lord. I have interim prayer for staying this because of suspense, I'm not able to make any business transaction, my lord.
My lord, I have an objection to the priority petitioner, my lord. While when the petitioner's registration was cancelled on October, my lord, with an alternative remedy, my lord.
Not been cancelled, my lord.
Suspended, my lord, under article under section 107 of the GST.
You can also file an appeal against suspension. Against suspension.
My lord, within 3 months, my lord.
No, you can file an appeal against suspension also.
Or another order, my lord.
Any order. Yes, why?
No, my lord, she will see section 107, my lord. No order is in passed, my lord.
No, what about the order of suspension? That is also an order.
No, lord, she will see, my lord, and it can only be suspended during the pendency of proceeding. No order is in passed for cancellation, my lord.
No, Mr. Mishra.
My lord.
See, order of cancellation is an order of suspension is also an order.
But then
will it cover an order of suspension also?
No, my lord. But it is so cause notice itself, my lord. In a so cause notice, there is observation, my lord. In a so cause notice. And the so cause is vague itself, my lord. It does not contain any particulars. How one can reply it, my lord?
Mr. Chaudhary, your colleague, Mr. Barua, has said that there is a provision for appeal.
Yes, sir.
Mr. Mishra is contending that it is not per se an order of suspension. It is an order of show cause. And in the said show cause, he said that pending the inquiry, the proceeding, the GST registration will be suspended. Now, can he avail the appellate provision?
Yes. Because here, first of all, he has not made any statement as to how all along he has been saying that he has not received this copy. Then how he came to know. Then he has taken the ground that there is no time limit for giving a reply, whereas it is clearly stated. And he has cited Rule 29, Rule 22, Lordship, that this so-cause cannot be issued. If that is so, those are the ground, Lordship. It was within limitation. He simply deliberately avoided that.
No, see, we'll examine this case,
Yes,
but he is praying for an interim order that in the interim, since his business has stopped, he should be allowed the registration should be restored so that he can carry out his business activities. That is his prayer.
Lordship may give me 1 week time.
Okay, well, okay.
Friday or not?
Next Monday. Next Monday. Heard Sri R.S. Misra, Learned Counsel, for the petitioner who is aggrieved by suspension of his GST registration, which was provided under the Assam Goods and Services Tax Act 2017, as well as the Central Goods and Services Tax Act 2017. Full stop. It is submitted that a proceeding has been initiated by issuance of a show cause notice without supplying any specific grounds, and on a vague ground rather than specific ground. Full stop. Para. Sri B. Chaudhary, Learned Standing Counsel, Finance Taxation Department, has submitted that I have prayed for some time to obtain necessary instructions. Para, list for motion on Monday. Give him an extra copy.
May I please, Your Lordship? Lordship, in this petition, I am challenging the eviction notice issued by the DFO Gwalpara. It's at page 44, annexure 8.
This eviction notice has been returned, Your Lordship, and the instruction of basic instruction.
Okay, then we'll record this. Okay. AC to deliver. Heard Sri D. Chaudhary, Learned Counsel for the petitioners. Full stop. The grievance of the petitioners is against an eviction notice dated 25/2/2026 issued by the DFO Gwalpara directing them to evict from the land under their possession on the allegation that the same is forest land. Full stop. Para. Three. R. Gogoi. R. Gogoi, Learned. Standing Counsel Forest Department has, however, placed before this court an office order dated 6/3/2026, whereby the impugned eviction notice dated 25/2/2026 has been withdrawn. Full stop. Para. This court is of the view that in the wake of such development, there would be no existing cause of action to be aggrieved with. But the para accordingly, the writ petition is dismissed, is disposed of for want of cause of action. Para, the office order dated 6/3/2020. No, don't say wanted. Accordingly, at this case, Sri Chaudhary, the Learned Counsel, submits that he would like to withdraw this writ petition in the because of the aforesaid development. Para. Accordingly, writ petition is dismissed on withdrawal. Para. Office order dated, copy of the office order dated 6/3/2026 is made part of the records.
May I please? Worship, the petitioner is challenging the proceeding that has been drawn up under section 152 of the BNSS. The petitioner is running a brick industry since the year 2010. On 9/1/2026, the proceeding was drawn up under section 152.
Yes.
However, my lord, because of the non-production of the pollution control board certificate from the pollution control board, as well as the permission of the Assam agricultural land, reclassification of land, my brick industry was put on hold. I cannot go ahead with the.
You said the section 152 of the BNSS is not applicable. It is applicable.
BNSS is applicable only with regard to pollution certificate. Pollution certificate I have obtained. I have produced before the authority. Now the authority has again come up with some other documents which are not related much. To draw up a proceeding under 152 only the.
What is the earlier writ petition 410/2026?
That is, my lord, I have challenged this order, my lord. That is, lordship will find a page number 42.
What is your name?
G. Bharadwaj.
Heard Sri G. Bharadwaj, Learned Counsel for the petitioner.
Order they have been given, my lord, that some of them, my lord, that documents they have been required by the district authority. But you may kindly see the page 62 and accept it.
Yes.
Lordship,
Yes.
3, 4, 5 as of 5. Whereas during the course of the further inquiry, the proceedings, the proprietor and the
authorized representative of the.
Failed to produce.
Failed to produce. My lord, these other documents we have, my lord, asked my lord to produce this one, but that was not been produced.
Well, in my case is only on these, man. These documents are not required to draw a proceeding under 150. Only the pollution certificate that is required. In fact, if your lordship is the last line, my lord, last line, my lord, we see. This order is passed purely in the interest of public safety and statutory compliance without prejudice to any other proceeding that may be initiated by this. They are already, my lord, the presumption is.
Okay, hard, who is aggrieved by an order dated 19/2/2026 passed by the co-district commissioner, whereby the petitioner is restrained to operate his brick kiln because of want of certain documents. Full stop. It is contended that though the said order has been passed in a proceeding under section 152 of the Bharatiya Nagarik Suraksha Samhita 2023, the same has taken into consideration irrelevant factors which do not constitute requirement under the aforesaid provision of law. Full stop. It is the specific contention that the said provision of the BNSS is only concerning a certificate from the Pollution Control Board, which the petitioner is in possession of, and the documents referred in the impugned order do not form a part of the ingredients of section 152. Full stop. Let notice be issued. Let us see BNSS. One hundred
152, man.
from where do you make this submission? That these documents would not constitute any of the ingredients of
Lordship,
152?
if my lord see the last impugned order, my lord,
Yes.
they have specifically stated that license from the fire authority is required under 152C. Section 13 of the Assam Fire Service Act, my lord, it only relates to warehouse or workshop, not related to brick industry.
See, these are subjective satisfaction. You have to make out a prima facie case. We are only considering your interim period. We are otherwise examining, but it is not the case that there are see 152 talks about it's like 133, isn't it?
Yes.
Earlier 133.
Earlier 133.
So
Lordship,
conditional order for removal of nuisance. So you are contending that 152 can at best include a pollution control certificate.
if something is injurious to health.
Injurious. What about the others?
Lordship, will kindly see page number 45, my lord.
Okay, well, interrupt on her. Okay, Kulu. That notice be issued, returnable on 8th of April 2026. 3 G. Hendrick, London State Council accepts notice on behalf of all the respondents. Extra copies. 3. The London State Council has, however, submitted that the projection made, that the contention made in respect to the interpretation of section 152 of the CRPC may not be correct, as the same encompasses many other circumstances which and those clearly appear to have been taken into consideration in the interim order, in the impugned order. Okay. We'll examine.
Lordship, the prayer for impeachment considered on the next step.
We are not satisfied. It will be rejected. Let it be there. Let him have the instructions. The aforesaid aspects would be considered at the appropriate stage.
Value.
45.
May please, Lordship. Petitioner, my lord, before Lordship deals in, my lord, ness of my lord, they transport buffaloes from the West Bengal and stock at my lord Dhubri district and sell in different district in the Lower Assam, my lord. But when the my lord, the vehicle entered into my lord, into Assam, my lord, there was my lord, various my lord, police station as well as Sakulia gate, as well as highway. The police stopped the vehicle and harassed the petitioners, my lord. And sometimes they detain the buffaloes also, my lord, without any reason, my lord.
Heard Sri H.R. Chaudhary,
Ahmed.
H.R. Ahmed, learned counsel for the petitioners
Right.
who are aggrieved by illegal obstruction and harassment caused to the petitioner in carrying out their business of transportation of livestock, that is, i.e., buffaloes, from West Bengal to Dhubri, Kokrajhar, Gwalpara, etc. Full stop. It is submitted that in spite of complying all the statutory requirements, the police personnel at the checkpost at Chagolia checkpost, police personnel at various checkposts, including the Chagolia checkpost, are harassing the drivers and other personnel of the petitioners. What's the para? Let notice be issued. Returnable on 8th of April 2026. Sri J. Hendrik for
129.
129, State Council 129. And Mr. Lokor? 10. CGC, yes, CGC. Okay. Extra copies.
Obliged.
PS, no? 36. Yes, Mr. Sikh.
Make lordship. My lord, petitioner before your lordships are allotus. My lord, they also applied for settlement of land, my lord, as per notification dated 11/11/2022. Now your lordship will turn to page 17 is the allotment order.
You have been allotted already.
Yes, my lord, allotted long back in 2007, my lord. Page 17, my lord.
Land was allotted.
It was on 21/8/2007.
Land allotted.
Yes, my lord.
What kind of land?
Land, my lord, it is allotment land, definitely all Sarkari land, my lord.
Okay, khas land.
We were in possession. Yes.
Khas land.
Yes, khas.
Not grazing land.
Not grazing land. Grazing land cannot be, my lord. So, my lord, all the petitioners before your lordship annex these allotment orders, my lord. Now your lordship would be pleased to see the acknowledgement after filing applications, my lord. They also acknowledged our applications. Your lordship would be turned to page 52 is the notification. That
Is there any eviction order as such? No.
My lord, eviction order is not there, but
you have the apprehension.
I humbly submit before your lordship.
You have the apprehension
At
that you might
least
be
in
affected.
Kolpara district, my lord, there is havoc, my lord. Eviction is done like anything. So, my lord, our apprehension, and I have stated in my petition, my lord, I have clear apprehension that I have stated in page 9, my lord, para 80, your lordship would be pleased to see.
Yes, sir, Mr.
Similar, my humble submission before your lordship, as allotment is in our favor, we are landless person. That is why allotment was given, my lord. So let the instruction come, my lord. Till that, my lord, that status quo on the land may be maintained.
No, we'll say that eviction process cannot be carried out without following the due process. Salekuddin.
Lordship.
Okay.
My lord, Salekuddin is, my lord, Salekuddin, here, my lord, your lordship will consider. Salekuddin is regarding encroachment of the people, my lord, on government caste land. Even some reserve land. Then the Salekuddin is to be followed. But my case is a bit different, my lord.
Now we are issuing notice at this
We
time.
are allottees.
Part 3MA6.
We are allottees, my lord. Let my friend, my lord, obtain instruction. Till then, status quo may be maintained, my lord, over the land. Because we are allottees.
MA6.
Salekuddin will not apply, my lord, in this case.
Lordship, my lord, they have applied for a land lordship only on the 12th December 25.
No,
So
that is
there's some process, my lord, it can be taken some time, lordship.
that is another aspect. my lord.
Hearts
We are allottees, my lord.
Hearts 3MA6. Learned
Allottees
counsel
in 2007.
for the petitioners. First of the petitioners, who are 11 in numbers, claim to have been allotted government caste land in a wide order dated 21/8/2007
Yes.
and are in continuous possession.
Yes.
Full stop.
Before that also, we were
They
in
have-
possession, my lord.
In full stop. In terms of a notification dated 11/11/2022, the petitioners have submitted online application for settlement of the allotted land. Full stop. However, it is the case of the petitioners that instead of considering their applications for allotment, comma, to the contrary, comma, a move to evict them is apprehended. Full stop. Para. Let notice be issued, returnable on 8th of April 2026, 3 Avenue, madam, and borderline 1, 2, and 3 by G. Hendricks. Full stop. 3 takes the learned counsel praise for an interim order. Full stop. Para. 3 Hendricks, the learned state council, has however submitted that that the petition has been filed on a mere apprehension and the application for settlement is of recent origin, namely December 2025.
25/12/2010.
And recent origin, namely dated, i.e. dated 25/12/2025.
They have applied for several debt, lordship. On the 26th also.
Of recent origin, including in the present year, including the present year. Para. Since no since it appears that there is an apprehension of the eviction of the petitioner before such consideration, it is submitted. The interim prayer appears to have been made on the basis of mere apprehension. Full stop. Be that as it may, the law is well settled in this regard that no persons can be evicted without following the due process of due process of law. More so, due process of law. Full stop. Further, the Honorable Division Bench, in the case of Salekuddin versus so-and-so reported, has clearly laid down the guidelines. Full stop. In view of the above, comma, it is directed that no prejudicial action be taken against the petitioner without following the due process of law. Full stop. Pendency of this writ petition shall not be a bar for consideration of the applications of the petitioner in accordance with law. '54. Yes, Ahmed.
Out of 10 ward, Miller, distributed schemes only 5. depriving the petitioners, my lord.
Just a minute. 10 words.
Yes.
Anchalik Panchayat.
No, my lord.
Now, which Gaon Panchayat?
Bahamura.
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 Where is it?
Borpeta, my lord. Under Mondi Anchalik Panchayat.
Bahamura GP. Under
Mondi
Mondia
Anchalik Panchayat.
AP. There are 10 words.
10 words.
What has happened?
My lord, 14,72,000 are distributed only to the 5 wards, my lord.
5 words.
Yes.
Who are you?
I'm the, my lord, ward number.
You're 3 petitioners.
Yes, my lord.
What members of 3 wards?
Yes, ward number 1, 4, and 5.
No allotment in your words.
Yes.
You're alleging discrimination in allotment.
Yes, in respect of distribution of the funds, my lord.
Yes, madam. Issue notice. But instruct that there has to be some semblance of equality.
Yes.
Some may be getting little bit more, but it cannot be that 3 of the words are not having anything. 14 lakhs that come. Did you submit any scheme?
Yeah, they did not give any opportunity, my lord. They dared to, my lord, without holding the Gausava, my lord.
Without holding?
Holding the Gausava, my lord, as per section 4 of the contract.
Okay. Third, Sri A.M. Ahmed, Learned Counsel for the petitioners. First of the petitioners who are 3 in numbers are ward members of ward numbers 1, 4, and 5 of the Bahamura Gaon Panchayat under the Mandia Anchalik Panchayat in the district of Borpeta. Full stop. The said Gaon Panchayat consists of 10 wards, and in the aspect of allotment of the distribution of funds in the various wards, no funds have been distributed so far as the words of the petitioners are concerned. Full stop. It is also submitted that there is a violation of the mandate of section 14, section 4 of the Assam Panchayat Act 1994, which requires convening of a Gram Sabha
Yes.
for such allotment of distribution. That notice be issued, returnable on 8th of April 2026. Madam Bora for 1, 2, 3. 1, 2, 3, 5, 8. And Bora, Standing Council PNRD. J. Hendrik State Council for 3, 4, and 7 by extra copies, then 7 by speed post with AD. Okay.
And Lordship order case 56, my lord.
What is it?
It is directed that disbursement made in accordance with law so that there is a proportionality.
Now,
Case 56. At that part maybe out.
Now this 12 lakhs, 14 lakhs have already gone.
Yet to be started what?
Huh? Now
What
there we
not
can
started,
interfere.
only schemes are prepared.
But where is the interim prayer? There is no interim prayer. How can there be an interim prayer here?
There is interim order. There is interim
Okay.
order. Appending
We are not going to stay. Sri Ahmed, the Learned Counsel, prays for an interim order for staying the operation of the impugned list of schemes. Full stop. Para. However, considering that the schemes are for developmental work, while this court is not inclined to pass a blanket interim order, for the funds which would be allotted in future, there has to be an equal distribution, equal proportional distribution for the various wards.
Yes. Obliged.
I think you can withdraw the petition now.
That's
37. Yes, Mr. Talukdar?
Yes.
May beg your lordship.
18 matter, what is this doing? 18 matter?
My lord, 2018 letter, my lord. Actually, my lord, the petitioners are founder members of this Shonville Fishermen Cooperative Society.
You are members of?
Shonville Fishermen Cooperative Society in the district of Karimganj, the now Sribhumi.
5562. How many of you are there?
Here, my lord, 28 petitioners.
28 people, members of cooperative society.
By the cooperative, Fishermen Cooperative Society.
Fishermen cooperative
My lord.
society.
Namely Shonville Fishermen Cooperative Society.
Okay, then what happened?
And this cooperative society was established in the year 1975, 51 years back, maybe, for the interest of the fishing community.
Yes.
And fishing community means here, my lord, both SC and OBC category. Both SC scheduled caste community people and OBC community people getting together from this cooperative society. Way back in 1975, 51 years back, my lord.
Yes.
And then, my lord, this society has been running in proper manner. And all the members of the that fishing cooperative society, my lord, have been participating in fishing affairs in the nearby Shonville and other.
What is your grievance?
Now, my lord, your lordship can see what grievance is that. You know, annexure 2 to 6.
Page?
Page 35. These notifications have been issued by the government of Assam. Annexure 2, page 35, my lord.
Yes.
This, our grievances start from this, my lord. This was issued by Joint Register of Cooperative Societies, Assam, Kanapada, Gauhati, 22, my lord. Directing, may I read, my lord? Sir.
Yes.
That's joint register to all joint register of cooperative societies except Gauhati and Kerala. Omission of members belonging to non-SC community from fishery cooperative societies. Non-SC members should be, my lord, removed from the fishery cooperative society. This notice was issued.
Yes.
With reference to the letters on the subject cited above, I am directed to request you to take necessary steps to omit the names of those members belonging to other than SC people in the fishery cooperative societies under your jurisdiction, issuing necessary orders to the fishery cooperative societies, fixing a specific agenda in the ensuing annual general meeting as per procedure laid down in the Assam Cooperative Society Act and rules. So this notification has been issued, my lord, to oust, my lord, to omit the names of the non-SC members from the cooperative society. And it was followed thereafter, my lord, by annexure 3 in the similar fashion.
Page
38. The annexure 2 continues, my lord, in the subject matter. Omission of name of members belonging to non-SC community from Fishermen Cooperative Society Limited.
Yes.
This was also issued by Assistant Registrar of Cooperative Society,
Yes.
my lord. Subject, omission of name of members.
You are aggrieved by this?
My lord.
You are aggrieved by this?
My lord, aggrieved by this.
But this is in consonance with law. Fishermen cooperative societies cannot consist of persons other than SC community. What is your grievance based on? What are your grounds of challenge?
Our challenge is, my lord, that we are the founder members of the cooperative society, Fishermen Cooperative Society, and we are also, my lord, belonging to the fishing community.
The fishing community you may belong, but the fishery rules itself makes it clear that it is only the SC community. Cannot other community cannot. You may indulge yourself in fishing activities, but you cannot be, because those cooperative societies are entitled to various benefits, and the objective is to give the SC community an impetus. That is the objective. Mr. Talukdar.
That is a policy decision.
Okay, we'll come back at 2 o'clock.
Maybe. Madam. According to my lord, Assam fishery rules, 1953, my lord, both the scheduled caste community and the Maimal community of the erstwhile Kasar district, presently Kasar, Sribhumi and Hailakandi, both the SC community members and the Maimal community members are kept on the same footing, my lord.
Yes.
In respect of, my lord, formation of fishermen cooperative
You
societies.
are referring to section?
My lord, section 12, my lord.
Rule 12.
Sorry, rule 12, my lord.
Hmm.
Rule 12, my lord. Yes, my lord. May I peruse, my lord, the same, my lord. Except those referred to in sub-rule number 8B above, all registered fisheries shall be settled under tender system of sale in place of operation, provided that the government shall settle a 60% category fishery with special category of cooperative societies, non-government organizations and self-help groups consisting of 100% actual fishermen in the neighborhood of this fishery concerned by the tender system. Next, my lord. For the purpose of this rule, the word special category means and includes the cooperative societies, self-help groups, non-government organizations comprising of 100% actual fishermen of the scheduled caste community or Maimal community of erstwhile Kasar district.
Yes.
Who cannot participate in the competitive bidding because of poor financial condition due to payment. And again, my lord, rule 6 also, my lord, says like this. Page 5, my lord. Rule 5, my lord.
Rule 5.
Rule 5, my lord. Rule 5, especially sub-rule 2.
Yes.
Rule 5, sub-rule 2, my lord. Any tenderers, including cooperative societies, formed by the communities other than the members of actual fishermen belonging to scheduled caste or members of Maimal community of the district of Kasar shall immediately after the acceptance of their tenders furnish in cash as security as sum equal to 25% of the revenue of the fishery for the first year of the full term of settlement. So my submission is that. So far as these were the fishery rules 1953 are concerned, my lord, both the, my lord, Maimal community members and the scheduled caste community members are kept on the same footing, my lord, and they are treated equally, my lord, in respect of forming, organizing fishermen cooperative societies and getting the benefits.
Yes.
My lord, under the cooperative society, my lord.
Yes.
And secondly, my lord, this cooperative society, my lord, the Shonville Fishermen Cooperative Society was formed in the year 1975, my lord, 51 years back, in collaboration with the scheduled caste community people, my lord. And for the last more than, my lord, 4 decades, 5 decades, my lord, we have been running the cooperative society together. And we are, my lord, purely, my lord, fishing community members. Our main profession is fishing, and the Shonville is our neighborhood, my lord, adjacent to our houses. And very peacefully we have been, my lord, managing our fisheries, and we are also getting.
So these are not grounds of challenge. What are your grounds of challenge?
Well, this is not.
Do you contend that the other OBC case should be treated at par with Maimal or SC? It cannot be. We have to make out some grounds that there is a direction for omission of the names of persons who do not belong to the scheduled caste community from the cooperative society of fishermen. You are challenging that. You are trying to build up a case that the rules itself recognizes Maimal community to be at par with SC community.
My lord.
So that is so far as Maimal is there.
My lord. We are Maimal community.
Huh?
We are a Maimal community members.
You are not Maimal community.
Yes, my lord. We are 100% Maimal.
Where have you stated?
Yes, my lord. You are not stated.
You are OBC community.
No, my lord. We Maimal at the same time OBC, my lord. We are 100% Maimal community people, my lord.
Where is it?
Yes, my lord. Page number 10, my lord. Page number 10, paragraph 2, my lord.
Yes, if they are Maimal, then
Yes, my lord.
where is this?
100% Maimal, my lord. The petitioners are Maimal community people belonging to.
We thought something else. You should have clarified at the first instance.
My lord.
You are saying that you are OBC. You have to say you are Maimals.
100% Maimal, my lord. There is no doubt about it. The petitioners are Maimal community people belonging to Bhairav.
I think there's some problem with the understanding. Perhaps they ignored Maimal, and maybe OBC they treated as OBC, therefore OBC cannot be scheduled caste. That was perhaps the objective, which cannot be stated to be unreasonable. But once Maimal comes in, which is recognized by the statute itself, then probably
Maimal cannot be excluded.
it cannot be
Cannot be.
excluded. Cannot be excluded.
Yes, well, what I find from page 40, well, there is a office communication by the registrar. And here, my lord, a report, my lord, of departmentally related standing committee on development department. So there are some reports from this particular, my lord, committee. So what is the rationale behind, my lord, this entire policy? Perhaps this will, my lord, make it clear. Otherwise, my lord, in my affidavit, this particular aspect is not borne into my that I clearly submit my Page 40, your lordship will see the registrar has indicated that there is a departmentally related standing committee on development department. And perhaps, my lord, there is an opinion from this particular standing committee. So rationale behind, my lord, this policy would be perhaps revealed or reflected from this, my lord, committee's opinion. Exactly what is, my lord, sought to be done.
You're for the cooperation department.
Yes, sir.
Yes, we share government, Mr. What do you say, government? And Mr. You're looking for whom? Oh, yes, supporting.
They've been instructed to delete the names of non.
No, you are supporting the petition, huh?
Supporting actually.
As per the instruction of higher authority, you have deleted the names of non-SC candidates. If they belong to OBC, you have.
But at the same time, we are Maimal committee member.
But on principle, whom are you supporting? You are supporting the petitioner. That you know, while the lease is on, we are deciding. You have to take a stand. You have acted. But are you disputing that the petitioners belong to Maimal community? They belong to Maimal community. I think there is some error in understanding. And the expression, these have been discussed in a number of cases, Mr. Roy. The expression is Maimal community of Kachar district, not in. So they may be Maimal community of, but they are residing elsewhere. There also they will get the benefit. It's not confined to only Barak Valley. Of
Ashwal Kasar district. It has been stated categorically, Ashwal Kasar.
Community has been specifically recognized by the statute. They may be otherwise OBC, we not know. But since in the SC, the concept would come only in Hindu. So far as Muslims are concerned, Maimal community also engages in fishing activities. So they have been included in the purpose of giving them benefit.
Exactly.
That is the purpose. Okay, we thought you had no case. You have a case. Okay. Look at you know. You are A.R. Talukdar.
My lord.
Heard Sri A.R. Talukdar, learned counsel for the petitioners. Also heard Sri S.S. Roy, learned state counsel. Sri S.K. Talukdar, learned standing counsel, cooperation department. And Sri M.H. Laskar, learned counsel for the respondent number 7. Considering that this matter, now considering the subject matter involved and also the aspect that the same is pending since the year 2018. The petition is taken up for disposal at the admission stage. Full stop para. The relief prayed for in this petition is as follows. Relief court para. As per the facts projected comma, the petitioners who are 29 in numbers belong to the Maimal community and are residents of Brajendrapur in the district of Karimganj. Full stop. They, along with some other persons, had constituted Sonbil. Please have your seat, Mr. W. Sonbil Fisherman Cooperative Society Limited, Karimganj, in the year 1975, and the said society was also registered. Full stop. The society was functioning smoothly, which was being run by a board of directors, by an elected board of directors. Full stop. The grievance of the petitioners is with regard to a direction dated 31/3/2008 issued by the Joint Register Cooperative Societies to take steps to omit non-scheduled caste members from the Fishermen Cooperative Society. Full stop. A subsequent communication dated 1/4/2018, no, 1/4/2020 or what? Page 38. A subsequent communication dated 1/4/2000. This is 2008 or what? Oh, 31/3/8 আছিল, 18. 8 আছিল. But why did you come to the court after 10 years?
All these years, they have been, the petitioners were trying pursuing the matter with the authorities.
You take 10 years to pursue.
Highlighting that
You should have waited for another 2-3 decades.
My lord.
You come in 2020, 2050.
They are real people.
10 years, what is your explanation? You are not aggrieved. You are very happy with the decision. You don't take 10 years to come to the court. That is not enough. That is not a reason. 2008, the same was followed by another communication dated 1/4/2008 issued by the assistant registrar to omit such names. Full stop. Para. Sri Talukdar, the learned counsel for the petitioners, by referring to the Assam Fishery Rules 1953, has submitted that Maimal community of Assam is statutorily recognized as a part of the fishermen community. Full stop. In this regard, he has drawn the attention of this court to Rule
5 and 12.
Rule 5 within bracket 2 and 12 of the rules of 1953. Full stop. He has submitted that the Maimal community of Assam cannot be treated to be at par with any other OBC of any other OBC of other places. Full stop. He has submitted that there is non-application of mind in the while issuing the impugned orders. Full stop. Para. Both three S.S. Roy, learned State Council, and Sri S.K. Talukdar, learned Standing Council, Cooperation Department, have fairly submitted that the intention was only with regard to giving the, was only to confine, with regard to giving the benefit to the actual fishermen and not to the persons belonging to OBC. Full stop. They, however, submit that the statute in question indeed treats the Maimal community of erstwhile Kachar district to be at par with the fishermen belonging to SC community. Full stop. Para. Sri Laskar, the learned counsel for the response number 7, has submitted that the secretary of the society has simply followed the direction of the respondent authorities. Full stop. Para. The rival submissions. Para. The Assam Fishery Rules 1953 clearly includes the Maimal community of Assam as belonging to the fishermen community. Full stop. There is a specific reference in this regard in Rule 5 within bracket 2 and Rule 12, which read as follows. Read a code 5, 2, and 12. Full stop. The objective behind the statute is very clear, so as to include the Maimal community of Assam from the benefit which would accrue to the actual fishermen belonging to scheduled caste community. Full stop. The impugned action which has been which appears from the impugned orders dated 31/3/2008 and 1/4/2008 do not appear to have taken into consideration the objective of the rules whereby Maimal community of the Kachar, erstwhile Kachar district is to be treated at par with the SC community, with the actual fishermen belonging to SC community. Full stop. Full stop. In view of the aforesaid discussion, this court is of the opinion that the impugned decision as conveyed by the orders dated 31/3/2008 and 1/4/2008 is unsustainable in law and are accordingly set aside. Full stop. Consequently, it is directed that the names of the petitioners be reinstated in the cooperative society. Full stop. However, before such reinstatement, a verification exercise be done with regard to the fact that the petitioners belong to the Maimal community. The said verification exercise be conducted expeditiously and preferably within a period of a month from today. Writ petition stands allowed in the manner indicated above. What is this 39? Yes, petitioner. What is this, madam?
The claim SUT value of the Kisan Vikas Patra. In 2002, they were purchased the Kisan Vikas Patra 10,000 each. Now, as per their claim, it was makes you 20,000 each. But as per our study, from 1995, the trust or execution have not accrued the difference factor.
It is not accrued to a trust. Why?
There is an credit notification lottery. Do not paying any interest.
You give interest only to individuals.
But if the percentage of 10,000 rupees and as per your calculation, it is 10,000, maturity value is 3,000 now. At our standing, they are not entitled to any interest.
No interest. Then why will somebody make KVP? Now there is no KVP also. So that is what we are asking. You give interest to individuals and not to trust. Is it trust you do not give interest? What is the logic behind this?
The application was, there was a legal application that trust execution will not get interest in this.
That notification has not been put to challenge. But petition is not there. Will adjourn this matter. None appears for the petitioner on call, whereas the respondent, whereas the Union of India is represented by Ms. R.D.B. Learned CGC Para. In the interest of justice, matter is adjourned to be listed on if I need to visit the phone like this. Who could do this vote? On we'll have it on madam on 16th. Yes, State Bank.
Chief, the matter can be disposed of, my lord, in the writing. So whatever, my lord, that 15 lakhs rupees was, my lord, credited to the petitioner account from a, my lord, FCRA account, my lord.
What account? FCRA mean?
FC, foreign contribution regulation accounts, my lord. Then in one complaint has been received from a charitable trust, my lord. And thereafter, my lord, that Delhi, my lord, hold back, my lord, 15 lakhs rupees, my lord. He is only account holder. They made the party because of that. He has opened that accounts in our office, my lord, our branch. Now, my lord, we wrote a letter to him, my lord, that their department, my lord, the bank want to know the source of coming, my lord. Kindly pay the page, my lord. My affidavit, page 47, annexure E.
You are alum. What is your name?
A. Rahman.
Mr. Rahman, you are an account holder.
My lord.
You are an individual or what? Individual.
My lord.
You have an account in Mr. Das's branch.
My lord.
What kind of account?
Is it
Saving
account?
SB account.
SBI.
SB account holder.
Yes, my lord.
In which branch? SBI.
SBI, my lord.
Hatsingimari branch. SBI Hatsingimari branch.
Hatsingimari.
My lord.
Then what happened?
My lord, kindly page 47, my lord.
47.
Yes, lord. Annexure E.
Yes.
6/10/23, my lord.
Has been made hold. 15 lakhs has been put to hold.
Yes, Lord.
Why?
My lord, that reason is due to complaint received by one of the authorized signatory of the entity named Christian Foundation Charitable Trust. The matter was narrated by you many times to your visit to the branch, and please submit the full details of transaction of 15 lakhs credit in your accounts on 16/1/23 onwards, submission of New Delhi branch, my lord. Now, my lord, still now he was not, my lord, informed to the branch, my lord, the source of coming of the 15 lakhs.
But why should you act on somebody charitable trust? What authority do they have?
This is that amount was credited, deposited, my lord, from a, my lord, FCRA account, my lord, foreign contribution. So, my lord, kindly look into that, my lord, page 41, my lord.
FCRA, foreign
Contribution regulation accounts, my lord. Probably, my lord. The region is there, my lord. Chief manager, page 41, my lord.
41.
41, my lord. This is a mail communication start from, my lord, 40, my lord. Finding is, my lord, 41, my lord.
Yes.
Finding observation of the branch, my lord, that transaction has been done apparently through a net banking facility. It does not appear in Sando with a FCRA purpose and MHA guideline, my lord. So this is a doubtful amount is, my lord, deposited, my lord, from foreign countries, my lord. Is the value.
Yes, what is your take on this?
My lord.
What do you say? Now you had asked him to come and explain.
Yes, my lord.
You go and explain from where it
Yes,
has
yes,
come,
yes.
that's all.
That is why I am paying, my lord. Let them, my lord, instruct, my lord, clarify the source of coming of the 15 lakh, my lord. Thereafter, my lord, department can, my lord, SBI will take a decision, my lord. That will be better, my lord. Can
Okay.
dispose of, my lord.
It's unnecessary. Why are you keeping this pending?
My lord.
2023. Yes, have your seat, please. Your A. Rahman heard Sri A. Rahman, Learned Counsel for the petitioner, also heard Sri K. Das, Learned Counsel for the respondent bank. Full stop. Para. Considering the facts and circumstances involved, and also as agreed to by the Learned Counsel for the parties, comma, the instant writ petition is taken up for disposal at the admission stage. Para. As per the facts projected, comma, the petitioner has a business of dry fruits, etc., and is having a license issued by the competent authority to run the same. Full stop. The petitioner has a savings bank account number, IFC number so and so, in the Hatsingimari branch of the respondent SBI bank. Full stop. It is contended that the transactions are done in the aforesaid account. Full stop. The grievance of the petitioner is with regard to the action of the bank to put on hold an amount of rupees 15 lakh in the account of the petitioner. Full stop. It is contended that no reasons have been disclosed to her, and the petitioner has been deprived of her legitimate right to operate her bank account. Full stop. Please have your seat, both of you. Have your seat. Sri Rahman, the Learned Counsel for the petitioner, by referring to the prayer made in this petition, has submitted that a direction be issued to allow the petitioner to operate her account. Full stop. Per contra, Sri Das, the Learned Counsel for the respondent bank, by referring to the affidavit in opposition filed on 13/12/2023, has submitted that certain transaction was found to be doubtful as it forms as the source was from foreign contribution. What is it? Foreign contribution regulation account within bracket FCRA, full stop. There was also a complaint lodged by one Christian Foundation Charitable Trust in this regard, full stop. Thus, the Learned Council has also drawn the attention of this court to a communication dated 6/10/2023, whereby the petitioner was advised to visit the branch and submit the details of the transaction to remove any doubt which had risen on the aforesaid transaction. He has submitted that in spite of the same, no steps have been taken by the petitioner to explain the position and remove the doubts. Full stop, para. Sri Raman, the Learned Council, has submitted that a direction may be given for the petitioner to visit the branch and make the clarification, whereafter the action of the bank to freeze the account may be removed. Full stop, para. The reason for putting on hold the transaction of the account involved has come to light after filing of the affidavit in opposition by the SBI. Full stop. It is clearly averred that there was a deposit of a major amount of rupees 15 lakh, which is connected with FCRA, and in that regard, there was also a complaint by a charitable trust. Full stop. Whether an action of freezing can be done only on the basis of a complaint by an individual would be decided in an appropriate would be a matter of deliberation. What appears from the communication dated 6/10/2023 is that the petitioner was advised to visit the branch to make the clarification. Full stop. Such a recourse by the bank cannot be said to be unreasonable when the amount involved is high and there is also a doubt which has arisen. Full stop, para. In view of the above, this court is of the opinion that instead of keeping this writ petition pending any further, the petitioner would be at liberty to visit the branch with the necessary clarification and explanation towards the deposit of the amount of rupees 15 lakhs in her account. Full stop. On furnishing of such clarification of the explanation along with relevant documents, if any, the bank will take an appropriate decision and communicate the same to the petitioner. Full stop. It is, however, made clear that if satisfactory reasons and explanation are given, the decision to keep on hold the account be revoked and the petitioner be allowed to operate the same without any hurdles. How soon can you visit?
My lord.
How soon can you visit the branch? 10 days.
My lord.
The petitioner, Sri Raman at this stage has submitted that within a period of 10 days, the petitioner will approach the branch. Full stop. Approach the branch, it is observed that on such approach, the directions made above shall be meticulously followed.
Receive the instruction file.
What is this, Mr. 42?
Yes.
42. What was their name? Jane, you are Jane or Singh?
H. Agarwal.
H. Agarwal. Oh, you are H. Agarwal, yes. Yes, what was it?
This is the petitioner is the proprietor of a cookful industry. He is operating the cookful industry in a lease from the possessor. So he has received one notice from the subdivisional officer for eviction of the property from the
Yes,
property.
I think it came before us on the first day.
Yes, Lord, sir.
Okay.
Now the affidavit is yet to be filed in this case. Sir.
Okay. Third, Sri H. Agarwal Learned Counsel for the petitioner, para. Sri S. S. Roy Learned State Counsel has submitted that instructions have been received and the affidavit would be filed shortly. Full stop. He accordingly prays for and is granted 3 weeks time. 3 weeks have to file, 3 weeks time to file the affidavit. Para. List on this 9th. We'll have it on 6th of, on 3rd is the holiday. 6th of April.
Interim order. Lord.
Interim order passed earlier to continue till the next date of listing. Yes, intern, have a seat. Don't stand like this. There are seats vacant. You're an intern or what? Madam, the person behind you. Have a seat. Seats are vacant. Yes.
May it please, Your Honor, sir. My lord, we filed this application for adequate compensation. Land has been acquisition. My lord, at this point of time, my lord, today, my learned friend has given me a copy of the particular award. We didn't have at that point of time. So, my lord, we want to approach invoking section 64.
Do you have the time?
That is why, my lord, I seek liberty from the national.
No, liberty we can grant you, but do you have the time? 64 days a time limit.
But I have gone through it, my lord. The date has not been given with award.
What are you saying? Let us see 64 some fair compensation. If 18 has
Yes, my lord, there is limitation.
Yes.
6 weeks from the date of award.
Yes.
But here award, my lord, date is not. I have seen it. Perhaps, my lord, it will be on record. When it is passed, my lord, I am not able to get it from here. Otherwise, it is 6 weeks from 21, section 21 notice and 6 months from date of award.
There are no provisions for delay condemnation. That is there. So you need to be very careful.
Yes, my lord.
Do you have the date of the award, Mr. Roy?
I have that award copy, Lordship, but the date is not there.
Okay, if there is not, then okay, what is the other petition? Similar?
Same, my lord. Same.
Okay.
Similar.
Item number?
My lord, we have received the copy today itself, my lord.
Okay. Heard Sri T. H. Hazarika Learned Counsel for the petitioners in these two cases. Also heard Sri S. S. Roy Learned State Counsel and Miss K. Fukan Learned Standing Counsel AEGCL, semicolon debug, last word, and Miss P. R. Mohanto Learned Standing Counsel, Revenue Department. Full stop. The grievance in these two writ petitions is with regard to the insufficiency of the compensation for land acquisition. Full stop. Sri Hazarika, the Learned Counsel for the petitioners, has, however, informed that at the time of filing of the writ petition, he was not equipped, the petitioners were not equipped or furnished with the copy of the award. Full stop. However, he has submitted that a copy of the award has been handed over to him by the Learned State Counsel. Full stop. He accordingly submits that since the Right to Fair Compensation Award Act 2013 provides for a remedy to make a reference under section 64 of the same, comma, he would avail the said remedy. Full stop, para. Sri Roy, the learned counsel for respondents do not object to the said proposition, para. In view of the above, comma, the writ petitions are dismissed on withdrawal, however, with a liberty to the petitioners to avail the remedy under section 64 of the Act of 2013.
My lord, but my lord, that this may be, I pray, my lord, maybe that may be clarified, my lord, since I have received a copy today. So, my lord,
Okay.
time may be.
Okay. At this stage, Sri Hazarika, the learned counsel, expresses an apprehension of the in the aspect of the limitation. Full stop, para. In view of the above, comma, since the aforesaid aspect has been considered, and it also transpires that the award does not bear any date. Full stop. Taking into consideration the above, and also and also the fact that the award has been handed over to the learned counsel for the petitioner today, comma, the limitation period would run only from today.
My lord, I'm deeply obliged.
Limitation period, as laid down in section 64 of the Act, would run from today.
My lord, deeply obliged, my lord.
Yes, madam.
Your Lordship, the LCR is not received yet, and the affidavit in opposition today only we receive.
Affidavit not filed.
Fine, but
You have served on Friday night. Saturday, we have served the copy.
Oh, today it has come. Oh, you have mentioned it today, I think. Oh, okay. Can we have it on some other day, day after tomorrow? Day after tomorrow, madam? Would you like to file any rejoinder?
my senior will know. But
If you take
My lord, while issuing notice, your worship has observed that, my lord, the maintainability of the reputation will be kept open. So, my lord, here.
What is the maintainability issue?
The maintainability, because of, my lord, primarily 3 grounds, there has been a delay, a very long delay. Number 2, my lord, the petitioner was never a party before the, my lord, the Assam Board of Revenue in the matter which has been settled in this case. And thirdly, my lord, there are no documents were placed before the court, my lord, to show the lineage of the, my lord, petition. On these 3 grounds.
Okay, let us do one thing. Let us have it day after tomorrow. In the event, you're led by Mr. H.R.A. Chaudhary.
Miss R. Chaudhary, Miss R. Chaudhary.
R. Chaudhary. Okay, she was there in the first step. In the event she prays for some time to go through, we'll see. Otherwise, day after tomorrow, we'll have it. Ask your senior to be here day after tomorrow, okay? While Sri M.K. Chaudhary, learned senior counsel for the contesting respondent, is present, comma, present, who has also submitted that the affidavit in opposition has been filed, comma, a prayer for accommodation has been made on behalf of Ms. R. Chaudhary, learned counsel for the petitioner, para. Considering the facts involved, comma, matter is adjourned to be listed on 11th.
Your worship, perhaps saying the maintainability of.
Those are open, you just point it out.
Yes.
46, who is for 46? Madam, you are for 46.
Yes, Your Lordship, the
Yes.
council is on legs in another court. Matter may be.
What
taken
is the
up after
matter?
some time.
Remission.
Yes, Your Lordship.
Possibly on last occasion, also to the director speaks of instructions that we have not received. As a on 25 and 26.
But this is going on since a long time.
There was a query from the legal court.
Competent authority takes almost a year to approve the minutes. And where is the question of there being a?
Whether there is.
Yes, we have. Why instructions are not there?
That was the query.
No, these are not in consonance with the Supreme Court's direction, Mr. Talukdar. You kindly apprise them, otherwise we will have to take some stern action, unnecessarily causing embarrassment. Who are the respondents?
Women political.
Women political will come before this court. Matter does not appear to have been taken in the right perspective, Mr. Talukdar.
As it appears, it was allowed by the board, state level review board. After that,
Heard the learned counsel for the petitioner. Full stop. The matter is connected with an application dated 23/12/2024 for remission. Full stop. Notice was issued on 19/1/2026. Whereafter, not 19/1. Notice was issued on 18/12/2025. And on the next date, that is 19/1/2026, this court had observed that this court had directed the Learned State Council to obtain instructions with regard to the meeting of the state level review board. Full stop. The matter had thereafter come up for consideration on 25/2/2026, when this court had made the following observations. Order date 25/2, following this court fails to understand. First page or last paragraph. Para, today, Sri B.J. Talukdar, learned additional senior advocate, learned senior counsel and additional senior advocate Assam has prayed for more time to obtain the necessary instructions. Full stop. Para. It clearly appears that the respondent state has not taken the matter in the right perspective. Full stop. In view of the same, while further time of a week is granted to obtain the instructions, it is made clear that if instructions are not provided, this court will have no other option but to have a personal interaction with the officers involved, concerned. Personal, don't say interaction. This court will have no other option but to direct personal appearance of the officers involved. List on Seventeenth March. We'll get this order uploaded today itself. You do whatever you want to. Yes,
May I
madam.
please, Your Lordship?
Item number
Item number 47.
47. Yes, madam.
This application against demand of value-added tax from the petitioners from the retrospective dates. Lordship. Lordship,
Yes.
the petitioners.
Instructions.
For some more time,
You have an interim order.
Yes, Lordship.
What is your name?
It does, Lordship.
Heard Miss Ada's learned counsel for the petitioner. Para. Sri H. Barua, learned counsel representing this Finance Taxation Department, prays for some more time to obtain the instructions. Para. Matter is accordingly adjourned to be listed on 27th of or 30th of March 2026. Para. Interim order passed earlier to continue till the next date of listing.
All right.
Okay, D Google exercise present. Huh?
Yes, ma'am.
Mr. Khan,
Yes. This is that matter, Your Lordship.
that matter will not do. There are 50,
But
60
in the
matters.
meantime, Your Lordship.
We will not remember everything. This is that matter. Which matter?
Yes, yes.
You have what
Herein-
matter?
herein-
We have 60 matters.
Yes, yes. Herein, Your Lordship, the petitioner had contested the Panchayat election and thereafter he won the election. But without hearing the petitioner.
R7 has appeared. Not appeared.
No, no.
Yes, what is the case?
The district commissioner, Your Lordship, without hearing the petitioner.
PNRD is there. Where is PNRD? Yes, Mr. Dutta, PNRD. Come. Yes.
And without hearing the petitioner.
Who are you?
I am the elected
Member
board member. Yes.
of a panchayat or
Panchayat.
Gaon Panchayat?
Gaon Panchayat, Your Lordship.
Petitioner Gaon Panchayat member.
Yes.
Then what happened?
And the present petitioner and the respondent number 7, they contested the election.
For president.
For Gaon Panchayat member, Your Lordship.
You won.
I won, Your Lordship.
You defeated R7.
Yes. And thereafter, the respondent number 7, he filed the election petition before the tribunal, Your Lordship.
R7 filed EP.
Yes.
Then thereafter?
Thereafter, the page 31, Your Lordship, kindly have a look. This is the order passed by the district commissioner. This order is basically issued on the basis of the complaint submitted by the respondent number 7.
Yes.
And without hearing the present petitioner, Your Lordship. And that too, Your Lordship, without following the rule 64, sub-rule 4.
You were not heard in the adjudication of the election petition.
The election petition is still pending, Your Lordship.
Oh, he filed EPO. This is a different proceeding.
Yes.
Deputy Commissioner, District Commissioner.
District Commissioner.
Which order?
Page 31, Your Lordship.
Page?
Page 31.
Date?
Date 19/12/2025.
What happened, District Commissioner? What did he do?
He removed the present petitioner, Your Lordship. He disqualified and removed the present petitioner, Your Lordship. Under section 111, subsection 2 of Assam Panchayat Act 1994 and rule 62, sub-rule 4, B and C of Panchayat rules 1995.
62, 4, B, and
62, 4, B and C of Assam Panchayat Constitution rules 1995.
What is your submission?
My submission is that, Your Lordship, this order, Your Lordship, is passed on the basis of the complaint submitted by the respondent number 7, who filed a election petition challenging the nomination of the present petitioner. So this order cannot pass on the basis of the complaint of the respondent number 7, Your Lordship. And apart from that, Your Lordship, no such hearing, nothing was taken, Your Lordship. And without hearing the present petitioner, this.
And you file an election petition under what provision of law?
No, I know, Your Lordship.
No.
It was filed with a
Understood.
129.
Section.
Yes.
129 is the bar, 127 is the.
Yes. I'm sure.
127.
Page 17, Your Lordship, kindly. Continue. Page 17, Your Lordship, that petition, Your Lordship, I have annexed.
District judge is the nominated
Yes.
election tribunal.
And regarding this issue, Your Lordship has.
Now, your deputy commissioner has taken action against at page 31.
Yes.
Yes.
Exactly, Your Lord. I have given one order, Your Lordship. It was
Yes.
by Your Lordship only, Your Lordship. And the subject matter is squarely same, Your Lordship. On same issue. In para 11, Your Lordship, kindly have a look at.
Let us see the impugned order.
Page 31.
31.
Yes. Page 31 is the impugned order, Your Lordship.
R7 is Zabeda.
Yes.
Mr. Khan?
Yes, yes.
R7.
Zabeda. Zabeda.
What is your name?
My name is Joshna.
Joshna Khatun.
Yes.
Yes.
And page 32 and 34, Your Lordship, these two documents, one is the admit card of the present petitioner, wherein the date of birth of the petitioner is mentioned, Your Lordship. And the next page, Your Lordship, page 33, that is the marriage registration certificate, Your Lordship, issued by the Qazi. Yeah.
Yes.
My lord, the first argument, my lord, that the tribunal and the power of district commissioner, my lord, those are totally different things, my lord. Because 127 was filed by another person, which doesn't have any connection with the rule of the district commissioner, my lord, having under rule 62, 4, B and C.
127 is filed by whom?
Filed by another third party, my lord.
Third party means, Your Lordship, the Zabeda Khatun, Your Lordship, respondent number 7.
Yes, sir.
It's election
rule.
election dispute.
Yes, ma'am.
127 is except for the president and vice president, where the deputy commissioner, district commissioner will have the jurisdiction.
Yes.
The others election matters are to be adjudicated by an election tribunal.
Yes.
Admittedly, we have an election tribunal. This district judge has been nominated.
Yes.
Has been declared to be an election tribunal. So there is an election petition pending, filed by the respondent number 7 against the petitioner. That is a admitted question of fact.
Yes. Yes.
Now, when that election is pending, now there is an allegation that she is involved in child marriage.
My lord.
Now, the first question is whether she was given any opportunity of hearing.
That is second part, I am coming to.
No,
that.
first is that.
But in that manner, I'll fairly submit, my lord. But in the first lordship, that is why I'm submitting part A.
Yes.
Part A, the district commissioner has the power because on in getting the information, he can directly go
Yes.
through a proper channel, my lord.
Yes.
But in the second part, petitioner has a case. That is why I'm fairly submitting, my lord.
Mm.
In the impugn order, my lord, itself, it is only about the birth of child, my lord,
Yes.
but not the date of marriage. The law is date of marriage, not the legal or illegal child. So I'm fairly submitting in that context that order is wrong. And second, my lord, the petitioner was not heard. That is also not correct. Therefore, I'm praying, my lord, lordship may remand back the matter to the district commissioner, my lord. Because district commissioner has the power under Rule 62 and BNC.
We have doubts. See, why two separate forums, two parallel, two proceedings have been contemplated so as to not to deprive of anybody to lodge a complaint.
My lord,
If you are a contesting candidate, you go to the tribunal.
my lord.
If you are not a contesting tribunal, because the tribunal will only see an election dispute.
So there is a notification.
So notification. But if you are somebody else, suppose a voter who is still aggrieved, Lucas may be a problem little bit, but you cannot make him or her totally remedialist.
Yes.
He can approach the concerned BDO or whoever, secretary.
My
He
lord.
writes to the BDO.
Yes,
So this as per number 7 cannot approach both the ways.
my lord. My lord, maybe my lord, respondent number 7 approached the tribunal because district commissioner, my lord, at that time, they didn't pass the any order. Initially, maybe.
No,
my lord.
that we are not too much concerned because R7 has not come before us. We'll interfere with this.
Because lordship, if lordship will pass, my lord, saying that two parallel cannot go, then the power rule under 62 to 4 V and C, that will.
No, that will not be redundant. That will be invoked if an appropriate person come. Appropriate person is not necessary
As
to
per
be
the rule,
become is not necessary that he was a contesting candidate.
As per the rule, my lord, the complainant doesn't, not required, my lord, in fact. On information, the Gauhati secretary or they directly, they can report to the district commissioner.
They can, but whether the district commissioner can totally ignore the aspect that this very issue is being looked into by a specialized tribunal. And then the aspect of giving her an opportunity, that is almost admitted.
For that, I'm with the petitioner, my lord. She should be.
But we will not remand the matter back. We will not say anything on the remand part.
Otherwise, what will happen in either way, my lord? One information was sent by secretary to the district commissioner, then they himself can file election petition, my lord, against themselves to lend the matter, my lord.
Who will file?
May, my lord, in future, other matter.
That will be decided.
Because it will become law, my lord.
No, why election petition, if it's filed, how will it be pending? The first day tribunal would say there's nothing gone.
Because district commissioner under district.
And why should a false petition be filed?
Some procedure.
Unless if you do not have any fault. See, these activities of indulging in child marriage, having more than 2 children, these are matters of scrutiny before and at the time of filing nomination. It's not that easy.
Yes.
If you overcome that, even thereafter there is some allegation, so it has to be looked from a circumspection. It has already undergone a scrutiny process.
Right.
Even then, you are making an allegation, so entirely burden is upon you. Simply by making an allegation, you cannot.
Yes. Petitioner will not prejudice because he has already annexed his legal marriage, which says it's after 18 years.
Okay, yes. Mr. Hendrik, anything you'd like to add?
On the basis of that order, the order passed by the deputy commissioner. And it is seen there, my lord, that no hearing has been taken by the concerned district commissioner.
Yes.
When I passed this order. As per the rule 62(4) B and C, my lord, the deputy commissioner has the power. My lord, without hearing, my lord, this has been passed. My lord, lordship can be given, my lord, that would have to the deputy commissioner. My lord, that the learned my lord, that,
The remand
petitioner
part would have been accepted by us without any difficulty if no election petition was pending. Unlike other cases, here there is an election petition pending admittedly between the same parties.
Lordship, suppose my lord, election petition is suppose my lord, after this order, my lord, he might have, she might have withdrawn this petition or not.
We do not know if there is no grievance of the respondent.
Then my lord, again my lord.
See, what Mr. Datta has submitted is that if any information is there, it can still be taken up. Let it be taken up. Let it be taken up in accordance with law. Give him a hearing. Why should we advise the deputy district commissioner? He take his. Okay, please wait. The extraordinary jurisdiction of this court has been tried to be invoked by filing this application under Article 226 of the Constitution of India pertaining to an order dated 19/12/2025, whereby the petitioner has been held to be disqualified from contesting for the post of member of a Gaon Panchayat and removed. Full stop. Order passed by the district commissioner Dhubri. Full stop. The relief prayed for in this petition is extracted here in below. Please 12. Quote kar dijiye. Para. Please have a seat, Mr. Khan. Para. As per the facts projected, the petitioner and the respondent number 7 had contested the election for the Gaon Panchayat from what number?
79/9 nong Sholmari Thit under 79 nong Jogirmahal Gaon Panchayat.
From 79/9 number Solmari constituency of the 79 number Jogir Mahal Gaon Panchayat under the Athani Anchalik Panchayat in the district of Dhubri. Full stop. In the said election, the petitioner had defeated the respondent number 7 by a margin of 17 votes and was duly elected and discharging her duties as a ward member. Full stop. The respondent number 7 had filed an election petition challenging the election of the petitioner on the ground that the petitioner had violated the provisions of the Prohibition of Child Marriage Act 2006, and the said proceeding is on. Full stop. However, wide the impugned order dated 19/12/2025, the petitioner has been 1912 passed by the district commissioner Dhubri, the petitioner has been held to be disqualified and accordingly removed. Full stop. Such order has been passed under section 111 within bracket 2 of the Assam Panchayat Act 1994, read with Rule 62 within bracket 4 within bracket small b and small c of the Assam Panchayat within bracket constitutional bracket close rules 1995. Full stop. It is this action which has been put to challenge in this writ petition. Full stop. I have heard Sri A.M. Khan, learned counsel for the petitioner. I have also heard Sri J. Handik, learned state counsel, and Sri S. Datta. No, not and semicolon Sri S. Datta, learned standing counsel, Panchayat and Rural Development Department, Ms. Kasta, learned counsel representing the State Election Commission. Full stop. The respondent number 7, though serves, has chosen not to appear and contest this writ petition. Full stop. Sri Khan, the counsel for the petitioner, has submitted that the petitioner was duly elected by defeating the respondent number 7, and her election is the subject matter of challenge in the election petition filed by the respondent number 7. Full stop. He has submitted that he was not at all aware of any proceeding before the district commissioner, who has passed the impugned order dated 19/12/2025 without giving any opportunity to her. Full stop. It is also submitted that the findings are incorrect and erroneous on merits, inasmuch as the petitioner has valid documents to show that she was not she was not involved with any child marriage. Full stop. In this regard, the learned counsel has referred to the date of birth of the petitioner appearing in the admit card and also the marriage certificate. Full stop. Para. Sri S. Dr. Learned Standing Counsel has submitted that there may not be an absolute bar for the district commissioner to undertake a proceeding under section under Rule 62, 4, B and C, even if an election petition is pending. Full stop. He has submitted that the district commissioner has been vested with powers to look into the aspect of any candidate indulging in child marriage or having only child marriage. This is only child marriage, isn't it? What about more than 2 children? That is also there. No.
No. More than 1.
So that will not come. Not come. No. Okay. Child. Involved in underage or minor marriage. Full stop. He has, however, fairly submitted that reading of the impugned order will not reveal that a fair opportunity was granted to the petitioner to defend herself. He has also submitted that relevant factors do not seem to have been taken into consideration while passing the same. Para. Sri Hendik, the Learned State Council, while endorsing the submissions of the learned Department Council, has reiterated that the objective of the aforesaid provision of law is only to ensure that a candidate contesting the elections for the panchayats is not involved in any underage or minor marriage, which is an offense under the particular provisions of law. Full stop. Para. Upon hearing the learned counsel for the parties and from the facts and circumstances emerging from the materials on record, it is not in dispute that in the elections held, the petitioner had defeated the respondent number 7, in respect of which an election petition has been filed by the said respondent number 7, which is pending. Full stop. Para. At the same time, what transpires from a reading of the impugned order dated 19/12/2025 passed by the district commissioner is that the said respondent number 7 had parallelly made a complaint before the district commissioner alleging that the petitioner was involved in child marriage and had furnished false information in the affidavit submitted with the nomination papers. Full stop. The impugned order also discloses that the matter was examined through an inquiry officer and certain facts have been stated. Full stop. The impugned order, however, does not disclose that any manner of opportunity was granted to the petitioner to defend herself in the said proceedings. Full stop. It is right law that before taking any action which has got adverse civil consequences, the person to be affected by such orders are required to be given an opportunity of hearing, as that is the basic requirement of law and is enshrined in the doctrine of audi alteram partem, inverted comma. Para. There is another aspect which is peculiar to the present case, which is with regard to the filing of an election petition by the same respondent number 7. Full stop. While the powers of the district commissioner under section 62(4)(b) and (c) is not doubted, which can be extended to take appropriate action for appropriate action against any candidate who is found to be underage or minor or indulging in or underage or minor during the marriage, the parallel proceeding initiated at the instance of the same respondent number 7 would be a factor which would play some role in the present case. Full stop. When the statute has laid down a specific provision for redressal of grievance in the form of instituting an election petition under section 127 of the Act of the Rules, Act, whether the same candidate or whether the same person who is a candidate can also file a complaint under section 62(4)(b) and (c) would be an issue which would require some deliberation. However, in the instant case, since the impugned order has been found to be faulty on other reasons, including the aspect of violation of the principles of natural justice, the said question would be answered in an appropriate proceeding. Full stop. Suffice it to mention that the aforesaid provision contained under section 62(4)(b) and (c) is to facilitate an adjudication, facilitate the district commissioner to take appropriate action when an information is received through the Gao Panchayat who is accordingly required to refer the matter to the BDO regarding underage or minor marriage that appropriate actions can be taken by the district commissioner. Full stop, para. In view of the aforesaid discussion, comma, the impugned order dated 19/12/2025 is set aside. Consequently, comma, the petitioner is to be reinstated back as a member of the Gau Panchayat, of the concerned Gau Panchayat. Full stop. Para. It is, however, made clear that the order of reinstatement is only with regard to the impugned order dated 19/12/2025 and will not have any influence and will not influence the adjudicating authorities who is looking into the election petition instituted by the respondent number 7 against the petitioners.
Okay, if you rule 62, it's something, there was section, but not a section.
Rule. Yes, rule 62 is rule 127 section.
Alright.
All right.
We'll see in an appropriate case that provision, whether election, we can.
I think in similar cases, on 13, report number 10, in similar cases are pending.
Yes.
All right.
Issue to DD.
This content that I have.
Item number
5, the content petition, due to incumbents change, transfer of a new incumbents, I have to take grace step here. Lordship. I file implicit petition.
you have filed implement. It has come or not? Has it been listed?
No, Your Honor. I will file your order.
You have filed or you will
No,
file?
I will file.
You will file, okay. We'll grant some time, okay. 3S Islam Learned Council for the petitioner has submitted that there has been a change of incumbents for which implement application is required to be filed. Full stop. Matter is accordingly this adjourned by 4 weeks to enable filing of such implement application. You have to send notice before that. Don't again commit the same mistake. Send a notice and enclose the enclosement of receipt. Okay. Yes, next. Yeah, item number. Mr. Laskar, he was there. Yes, Roy. And appears for the parties on call. Petitioner on call. Petitioner on call. In the interest of justice, matter is adjourned to be listed on Monday next. 16th.
May it please your lordship, my lord, I am appealing for the respondent number 5, IA 708.
There's an IA.
IA 708 is there.
708, yes. My applicant is the R5.
My lord, I am for appeal. The order, my lord, which
IA for?
IA for modification, vacation, alteration of the interim.
Objections filed, Mr. Abidin?
No.
First
Just
time.
First time.
Would you like to object or what?
Well,
No.
only one thing, if my friend other side agrees. The point over here, whether the meeting call was under 10-6 or 10-9. So with that.
Meeting for?
Meeting for requisition, the requisition for no confidence motion against the chairman of the
Cooperative society.
cooperative society. The meeting was called, as I stand say that it is under 10-9. After the requisition, the meeting was called. It is valid. The registrar says, no, the meeting ought to have been in the manner of 10-6, giving 1 week's notice, clear notice. And we say that under 10-9, it is not 1 week clear notice, it is the meeting to be held within 1 week from the date of receipt of the requisition. So if your lordship looks at the first order, over there, the interpretation of 10.6 and 10.9 is only required. Otherwise, the case is, suppose your lordship holds as yes, 10.6 is applicable, then I'm out of the court. So whether still, I say on that point, I think a date can be fixed, like admission hearing, we can do it the matter. Or otherwise, another thing, I think I had a suggestion that can it be remanded back to the registrar, saying, please, you said 10.6, now it is in the 10.9. You please look into the matter again. If this insist on this IA, then
We can have this tomorrow for the final filing hearing.
Not
Yes.
tomorrow, tomorrow, little bit of other hearing matters are there.
Then next Tuesday.
Next Tuesday? Oh, yes. Next Tuesday.
Next Tuesday.
Oh.
Mr. Kayum?
Yes,
Next.
I am intending for the lesson number 4 million, the second. My problem is that due to maybe stress or scope, the fund cannot be distributed to the
So wait till next Tuesday. Thereafter, status quo will be vacated.
The whole issue between all of us is the fund.
Is the fund.
Is the fund.
no,
We heard it is whole issue is fun.
Not fund, well, fund. FUND, my
No,
lord.
that is fun also.
That is also fund. Well,
Hardly any difference between fun and fund.
no, well, no fund, no fund.
No fun.
And Talukdar knows it very nicely, my lord.
but it's a fact that while this fight is between the petitioner and the R5 is going on, the consumers as well as these people over there working, they are not getting their salaries. So I'm just.
Oh, next Tuesday. Okay.
Yes.
This will be in common, huh? Heard 3. J. Abedin, learned counsel for the petitioner. Also heard Sri S.K. Talukdar, learned standing counsel. Corporation Department. For Sri P.K. Roy Chaudhary, learned counsel, is present for respondent number 5, who has also filed IA 708 of 2026 for modification, vacation, alteration of the interim order. Sri D.A. Kayum, learned counsel, is present for the respondent number 4, the secretary of the cooperative society. Full stop para. There is a general consensus in the bar that the matter that the dispute involved would be with regard to an interpretation of section 10
Clause 10C and 10.9 of the bylaws.
of clause 10. Clause 10 of the bylaws, more specifically, whether clause 10.6 or clause 10.9 would be applicable under the facts and circumstances of the case. Full stop. Para. That being the position, comma, Sri Abedin, the learned counsel for the petitioner, has submitted that there may not be a requirement to file an objection to the IA, and the whole writ petition can be taken up for consideration. Full stop. Para. The aforesaid submission is also gets support from the learned department counsel as well as Sri Kayum, who has stated that it is the consumer and the general people who are suffering because of the order of status quo. Para. Considering the above, comma, list this case for admission hearing on 17th. 17th. Interim orders past earliest times extended till the next date of listening. But 17 will go for final hearing.
Yes, madam.
Yes, Mr. Daga.
My lord, I have filed an IA lordship.
Yes.
Lordship, in that IA, I have prayed for stay of 2 emails which has been given by the HDFC Bank lordship.
Yes.
And also with regard to other respondents, not to take any course of actions
for deducting or.
What is the subject matter?
What has happened, I have been subjected to online fraud on
Okay.
22/10/2025.
You are an individual.
I'm an individual, Lordship.
You have an account.
I have an account, Axis
Where?
Bank, Axis Bank.
Axis Bank, SB account.
Yes, savings account. And I have got 3 credit cards. And I have also a bank account in PNB Bank. I have got 3 credit cards. First credit card is of IDFC Bank. Second is of HDFC Bank. And the other is on the other is of Axis Bank only.
One Axis.
One Axis, one HDFC, and one IDFC Bank.
And what is IDFC?
IDFC Bank, Lordship.
Okay, it's also a bank.
IDFC
You have
First
3
Bank.
credit cards. Okay, then.
Yes, Lordship. Now, on 19th of October, 19th of on 14th of October 2025, I have approached the PNB for an online credit card.
Oh.
Now they have said that now there is no provision for going to the branch and applying for a credit card.
Yes.
You have to apply online.
Yes. You had applied.
Yes, on
1410.
on 15/10 I have applied online.
You said 1410, it's 1510.
14/10 I went to the bank.
Okay, 1510 you applied for.
Yes, Lordship. And then on 22nd, 22/10/2025, I have received the call, wherein in the caller's ID it was written as PNB Bank. Now they were asking me some different type of questions for 20 minutes. Then they have cut the call. Immediately, Lordship,
Yes.
there has been some transactions happening all through my 3 credit cards.
Okay.
So, Lordship, total Lordship, they were transacting with the Flipkart. Total 6-7 transactions happened. Out of which, Lordship, the banks has given me mail that something that this doesn't align with the way of, and then they have stopped the transactions. With regard to HDFC Bank and IDFC First Bank, they have stopped 3 transactions each. But 1 transaction they have allowed.
Who? IDFC? HDFC?
Both the banks. So, Lordship, I have given a mail that I have raised a complaint that this has happened, that will happen. Now, the HDFC Bank and IDFC Bank came up with a view. Lordship may kindly take up, that it will be easier. Lordship may kindly take up the writ petition, Lordship. In page number 61, that is their reply. Of the writ petition.
Yes.
Dear Mr. Peter, kindly note the unique reference number of this correspondence is so-and-so. This is with reference to your complaint number so-and-so filed before the Office of the Banking Ombudsman regarding HDFC bank credit card amount. We understand from your communication that you have concerns regarding transaction of rupees 3,26,661 incurred in Flipkart on 22nd October 2025 on credit card. We have reviewed your queries and wish to clarify the same. We clarify to you that the bank has a robust system in place to protect customer details. We have observed a transaction of rupees 2,58,000 so-and-so, rupees 2,858,000 so-and-so, and 3,26,000 so-and-so were declined, and IVR call and WhatsApp communications were initiated to the registered mobile number maintained in our records. The bank on receipt on confirmation regarding the transactions incurred in the account number. Further, our bank representative also contacted the registered mobile number to confirm the transaction of rupees 326 so-and-so, and the bank was in receipt of confirmation of the transaction incurred in the card. So this is their statement. Now, Lordship, may kindly redirect to page to Annexure 1. Page number 32.
Now, in this IA, what are you paying?
Now, Lordship, this is a case where my mobile number was hacked. Now, Lordship, kindly, I'm praying, Lordship, page number 32, they have stated
transaction check alert. We tried to contact and confirm so and so amounting rupees 3,26,661. So they tried to contact, but they could not contact. Now, Lordship, in this regard, I have filed a FIR saying that from 10 a.m. to a certain date, to a certain time, my mobile number was hacked. That FIR, Lordship, would find, and I have also complained before the cybercrime division, Lordship. These are annexures, annexure 4, Lordship, with regard to this HDFC Bank. We tried to call you and verify and confirm the recent transaction, but we are unable to connect. Lordship, page number 48, that may be marked, Lordship. It's the HDFC Bank who says that. Now, Lordship, after that, Lordship, what has happened? They are trying to now reimburse that credit card amount from me. That 3,26,000 odd, Lordship. Both the banks, Lordship, IDFC Bank and also the HDFC Bank. Now, Lordship, I would like to rely on the case law of this honorable court, Lordship. This issue has been already settled, Lordship, if I may. Yes, sir.
Which one? Bhumik's case?
Yes, yes.
No, what do you want in your IA now?
No, IA, Lordship, they have, I'll just place the IA. What they have done, they have sent me a mail. In that mail, they have stated that they will, I have two, Lordship, two fixed deposit, Lordship. They are trying to lien that amount to and balance it with the credit card amount. Lordship, may kindly see this. Annexure 2 of the IA. Dear customer, subject, intimation of lien set off of FD amount so and so in respect of the outstanding dues. This is to advise you that due to irregular payment, your caption credit card amount is overdue. We regret to note that despite repeated...
Yes, Mr. Chakraborty, your phone.
Evidently, not here stated that his phone was hacked.
Yes.
So when the phone was hacked, we are not the operator of the phone. But then, when OTP based transaction happened, we have to honor the transaction. That is the status. So for the third transaction is confirmed, yes, the OTP, you have the OTP.
Now, how do you balance the equities? You may be correct. So how do you balance the equities? Prima facie, he is taking out a case that he was duped, his mobile was hacked. Now, we are not asking you to replenish or whatever. He is asking that do not make any adjustment with the two fixed deposit for the time being.
For that matter, he has already signed when he applied for the credit card, there are certain clauses for it, and the bank has a lien.
No, if he fails normally, then the bank will definitely have a lien.
Yes.
Now, this is a peculiar facts and circumstances where he is trying to make out a case that he is a victim of some fraudulent activities.
Prima facie.
Only prima facie. That is not our final.
Yes.
And who's for the other bank? One is by HDFC, one is by. These two bank deposits are in which HDFC only.
HDFC.
So your present claim is against HDFC.
In the writ petition, I have.
No, the writ petition.
Yes, Lord.
You do not make adjustments till we adjudicate the matter. Madam? BSNL. You file your return in the writ petition, we'll decide the writ petition. We'll decide it in an early date. We only want to make sure two things. One is a more important thing, his complicity. First, his complicity. If there is a little hint of his complicity, then totally out. Then second, first is a very difficult thing. Probably no one will come with a hand in being a hand in dog. Second is the aspect of latches. This court has said that this matters of latches, you cannot equate with anything. You cannot expect an action immediately. But there should not be an inordinate delay. At times you are negligent, but It depends who is the person, how is he. In some of the cases, we have found elderly couples being due. In the case of Mr. Bhomik,
Yes.
division benches also. So all these aspects are, and these are all new issues. Earlier, it was not, 2 years back, it was not there. Nobody could have even thought of a cyber offense that your account has been siphoned off. Earlier, it was done physically. Now,
Respect to the views from the portal, Malad, is be necessary because if he has already lost the complaint immediately, Malad, I think there is some mechanism to bring back the.
no, you just imagine a situation that a transaction is done, phone is not working. You due diligence you do. Normally, we also get a check has been found. If that is not you, kindly intimate us. Everywhere. Now that he says that at that time phone was not functioning, it is possible. Then if you do not get a negative message, you'd go ahead with it. At least this court can say that whenever we get a message, we do not reply. If we see that there is no fraud in, or no, it is a check issued, indeed issued by me, unless I doubt it. So no response means go ahead. You went ahead, but we have to adjudicate, balance it. Okay. Heard Sri P. Nath.
P. Dekar.
P. Dekar, Learned Counsel for the applicant petitioner, who by means of this application has paid for staying of 2 email communications, both that dated 3/3/2026, issued by the HDFC Bank, pertaining to fixed deposit account numbers, date is here, page 70, so and so. Full stop. The petitioner has also, or the applicant has also prayed for restraining the respondables 1 and 2 from prematurely redeeming the aforesaid fixed deposit for adjustment of funds against the credit card account. Full stop. The applicant has filed the connected writ petition on the with the allegation of cyber fraud being committed upon him, which committed upon him. Full stop. It is contended that in connection with an application for an online credit card from the PNB, he had received a call which was stated to be a verification call, whereafter there were immediate transactions with the earlier credit cards which the petitioner was using. Earlier 3 credit cards. Full stop. Though the transactions were stopped, 1 transaction was allowed, amounting to rupees
3,26,000.
3,26,000.
661.
661. Full stop. The petitioner and the applicant claims to have lodged Ajahar and had also submitted that though the bank claimed to have issued a verification SMS, at that relevant time, his mobile was also hacked.
Verification call launch.
The SMS.
SMS call.
I think you have given an SMS.
SMS, yes.
SMS, not a call. Verification SMS, which was not, as the mobile was hacked. Full stop. Para. 3. R. Chakraborty, Learned Counsel for the HDFC Bank, has submitted that due diligence exercise was done before honoring the transaction, and it was only thereafter that the same was allowed. Full stop. He has submitted that the emails dated 3/3/2026 have been issued in accordance with law and as consented to by the petitioner while applying for the credit cards. Full stop. Para? Upon considering the facts and circumstances and also the aspect and also the allegation made by the petitioner that he is a victim of cybercrime, which is tried to be substantiated by the documents, this court is of the view that the equity would be balanced if an interim protection is granted so far as the emails dated 3/3/2026 pertaining to the two bank account, two FD accounts are concerned. It is accordingly directed that till the adjudication of the dispute as raised in the writ petition, no steps be taken to prematurely redeem the fixed deposits of the aforesaid two accounts against any outstanding and against the outstanding in the card account of the petitioner, of the applicant. Full stop. The present interim order has been passed only on the peculiar facts and circumstances and will be subject to the final orders that may be passed by this court in the writ petition. I stand disposed of.
Lordship, this acknowledgement for that cybercrime, my Lord senior friend has also said, if a report may be called for, it will be helpful, Lordship.
Are there parties here?
Lordship, parties are there, Lordship.
We cannot say, but this, let us see. List, the writ, I stand this one in the writ petition, right? IC 753/2026 has been disposed of today, whereby an interim protection has been granted to the petitioner. Full stop. Let the contesting respondents file their response by the next date. Full stop. List this case on. We'll have it on when? Before Bihu vacation?
Yes, Lordship.
On 7th of April.
Highly appreciated.
Picnic.